Good morning, everybody. It is a real pleasure to be here on the campus of Shepherd University, and we are very grateful for the hospitality shown by President Dr. Mary Hendricks and her entire staff. This is a wonderful venue, and we appreciate the opportunity to kick off our series of civil rights enforcement forums right here in Shepherdstown. In addition to the university, we have the support of the Martinsburg Rotary Club and the Martinsburg Initiative, and for that I'm also very grateful. Today's forum is being held because of the need to raise awareness about civil rights possessed by all West Virginians and all Americans. Too many people don't fully understand certain of their rights, and so today we will discuss some of them and how they can be enforced through civil actions and through criminal actions. Examples of civil rights laws include the Fair Housing Act, the Americans with Disabilities Act, and the Voting Rights Act. Criminal civil rights enforcement includes the prosecution of hate crimes, law enforcement misconduct, and human trafficking, just to name a few. We won't be able to cover everything today, nor will we try to cover everything today, but we hope that this event will raise some awareness about rights that many people don't even realize that they have. The enforcement of civil rights is a priority for the United States Attorney's Office, and we will be devoting more resources to it in the months and years to come and engaging with the public on a more regular basis. Events like this one will be held in Morgantown on October the 11th and in Wheeling on December the 8th. The public should know that civil rights complaints may be made directly to the U.S. Attorney's Office at the address that you will soon see here on the screen. And also by calling the phone number that you see on the screen. There's also a form on our website that may be completed and submitted in order to make a civil rights complaint. So the enforcement of civil rights makes communities in West Virginia safer and stronger, and we will enforce those rights vigorously, and we welcome the public's input in identifying violations of civil rights. Now it's time to hear from our keynote speaker. It's an honor and a privilege to introduce Kristen Clark, the Assistant Attorney General for Civil Rights for the United States Department of Justice. Assistant Attorney General Clark is a champion for civil rights and for all Americans and has been dedicated to this cause since the beginning of her professional career, which began at the Civil Rights Division that she now leads. After her initial stint at DOJ Civil Rights, she went on to lead the Civil Rights Bureau for the New York Attorney General's Office. She was a leader with the NDWV's Legal Defense Fund and executive director of the Lawyers Committee for Civil Rights under Law. This is a lifelong passion for her, and there's no one better to kick off today's forum than the Assistant Attorney General for Civil Rights for the United States Department of Justice, Kristen Clark.
You can start whenever you're ready. You can start whenever you're ready. Ms. Clark, you can start whenever you're ready. Apologize, guys. That link expired unexpectedly. Just give us 1 second. Technology is great when it works, right? She's working to reconnect.
I am pleased to introduce our first presenter, Mr. Chris Prezioso. He is the Civil Division Chief and Healthcare Fraud Coordinator at the United States Attorney's Office. A large portion of Chris's practice focuses on affirmative civil enforcement actions. He works closely with government agencies and whistleblowers to recover money lost to fraud and other misconduct. Chris's presentation today will focus on the Fair Housing Act and False Claims Act, and he will explain the statutory mechanisms for enforcing an individual's right to fair housing. Chris, the floor is yours.
Use this one right here. Thank you very much, Bill, and what an honor to share the stage with the Assistant Attorney General, Kristen Clark. As Bill mentioned, my name is Chris Prezioso. I work with the United States Attorney's Office. I'm in the Wheeling office, but from 2003 to 2015, I practiced law here in the Eastern Panhandle, and I'm really glad to be back. And I'm thankful that Shepherd had us here today for these important topics. As Bill mentioned, I'm the Civil Chief, and I'm also the Healthcare Fraud Coordinator, and I spend a large portion of my time in the affirmative civil enforcement realm. And today I'm going to talk to you about the Fair Housing Act, which is found at 42 U.S.C. 3601 et sec. I'm also going to talk to you about the False Claims Act, but I promise I will not bore you with a bunch of statutory mechanics. It is pretty interesting here. The Fair Housing Act, if you don't know, prohibits discrimination by direct providers of housing, such as landlords. And it makes discriminatory practices, prohibits discriminatory practices when housing is made available based on race or color, religion, sex, national origin, familial status, or disability. And the FHA provides procedures for handling individual complaints of discrimination. So I'm going to get into that a little bit because it's not exactly very clear when you read the statute. But I think when you're done here today, everyone will have a good understanding of how to file certain complaints pursuant to the Fair Housing Act. And individuals, just briefly, may file a complaint with the Department of Housing and Urban Development, or HUD. I'm going to be referring to HUD a lot today. Or file their lawsuit in federal court or state court on their own. And the DOJ brings suits on behalf of individuals based on referrals from HUD. And as Bill mentioned, there are certain suits you want to refer directly to our office. So again, to start here, the Fair Housing Act prohibits housing discrimination on the basis of the following protected classes: race, color, religion, sex, disability, familial status, and national origin. What are some of the things the Fair Housing Act prohibits? So I just talked about and mentioned all the protected classes, and if there's any discrimination towards those protected classes, these are some of the acts that the Fair Housing Act prohibits. Refusing to sell or rent after making a bona fide offer, refusing to negotiate for sale or rental of a dwelling, making unavailable or denying a dwelling, discriminating in terms, conditions, or privileges, or in the provision of services or facilities, making, printing, or publishing a statement or advertisement indicating a preference or limitation. And it's important to remember that the FHA applies to pretty much any type of housing, not just government subsidized housing, not just apartment complexes. It also encompasses things like homeless shelters and group homes, because the FHA applies there as well. Also prohibits representing that a dwelling is not available when in fact it is, discriminating in residential real estate related transactions or in the terms or conditions of such transactions, intimidating, threatening, or interfering with any person for exercising his or her housing rights, and prohibits criminal threats, use of force, intimidation, or interference. Some recent examples of some FHA cases: United States versus Collier out of the Western District of Louisiana dealt with allegations of race-based intimidation, harassment, and retaliation under 42 U.S.C. 3617. United States versus J&R Associates involved allegations of a pattern or practice of discrimination and or denial of rights to a group of persons on the basis of racial steering in violation of 42 U.S.C. 3614, and United States versus the Home Loan Auditors, which involved allegations of a pattern or practice of national origin discrimination when they targeted Hispanic homeowners for predatory mortgage loan modification services and interfered with those individuals' ability to keep their homes. Now, I bring up these three cases because this shows you kind of the wide variety of the kind of cases the DOJ can pursue under the Fair Housing Act. I also bring this up because if you'll notice, each one of these was resolved by an agreement. The first case I talked about was resolved by a consent order, and the other two were resolved by settlement agreements. And later on in the presentation, I'm going to talk to you about one of our most successful civil prosecutions here in the Northern District of West Virginia, which was also resolved by an agreement. So this is where I mentioned before, there's a little bit of nuance here with how the DOJ enforces the FHA. So the Attorney General, which is our office, the Department of Justice, can bring an action in federal court when there is reason to believe that a person or entity is engaged in a pattern or practice of discrimination, or where there has been a denial of rights to a group of persons that raises an issue of general public importance. And you heard Assistant Attorney General Clark talk about that pattern or practice. Now, that doesn't mean the DOJ cannot bring suits on behalf of individuals in individual instances. And in fact, the DOJ may file suits for individual instances of discrimination pursuant to the Fair Housing Act, but that only occurs when the Department of Housing and Urban Development, HUD, refers the matter to the DOJ. Now again, we're talking today about the Fair Housing Act. Bill at the very beginning put up the slide that talked about reporting civil rights violations. That doesn't apply to all the other civil rights violations. You can refer those directly to our office, and we certainly encourage that. But for housing, FHA, individual instances of Fair Housing Act violations, those have to be referred directly to HUD. Obviously, if we receive them, we're going to pass them along as well. So what do I do? What do you do if you're a victim of housing discrimination? So you can, if you're a victim of housing discrimination in violation of the FHA, you can file a civil lawsuit within 2 years after the occurrence or termination of the alleged discriminatory act. You can do that on your own. You can also file a complaint within 1 year with HUD, and you should also file that with the West Virginia Human Rights Commission. Now, if there is possible criminal conduct involved, and I'm going to talk to you about some potential criminal conduct soon, you should always call local law enforcement or the FBI. Do not put yourself in danger. I know it's important to preserve any type of claim you may have in a lawsuit, but don't put yourself in danger. Call law enforcement immediately. And if you have information that suggests a pattern or practice of discrimination in housing, submit a complaint form to the Northern District of West Virginia Civil Rights Team using the complaint form at this address down below. And I'm actually going to pull up here and show you. When you go to that website, this is what our website here looks like. We have a page here for our civil rights program. And you'll see a link that says how to file a complaint here. And when you click on that link, you will see our complaint form. Now, I do want to point out to you that you can see the very first box there says a fair housing complaint. But also, we have boxes for human trafficking, military veteran status, disability rights or access, credit or lending opportunities, employment discrimination, educational opportunities, and others. So again, if you're experiencing any type of civil rights violations, we have a form here and some of the other information that was provided. But again, with the pattern and practice, we'll get that form, and that's one of the claims that we can bring on our own without a referral from HUD. There is and speaking of HUD, there is a nationwide initiative for HUD to stop sexual harassment in regards to housing. And as you may or may not know, sexual harassment may actually end up result in a violation of the HAA. So, again, many of you came here today may have familiarity with the Fair Housing Act and what it covers and prohibits, but what you may not know is that even with sexual harassment, that may also be covered by the FHA. So we're going to spend some time to talk about this initiative, how to report it, and again, it's not maybe immediately intuitive to think sexual harassment may be protected by the FHA, but it is important to discuss. We all have a working knowledge of that. So what are the primary categories of sexual harassment that may end up in violations of the FHA? Those categories, there's 3 categories. Well, first one being quid pro quo. Second, hostile housing environment. And 3, retaliation. So if you're aware of law involving employment discrimination, as some members of our audience may be, these will look probably pretty familiar to you. In regards to the quid pro quo, that is where a housing benefit is offered only in exchange for some type of sexual act or things of that nature. So you'll hear things like, if the apartment is still available to you if you do this. I won't run a credit report if you do this. I'll make repairs if you do this. You can pay me later if you do this, and I can charge you less if you do this. And these are all examples from real life cases. Now, it doesn't matter if the resident ever acquiesces to the demands. Those still may be there's still a claim for sexual harassment. The next category, speaking of, is hostile housing environment. And this is when you have severe or pervasive sexual harassment that occurs all the time or on a continuing basis. That may result in sexual or suggestive comments, showing of pornography, exposing self, repeatedly entering the housing, unwelcome sexual touching. Now, even though the Hostile Housing Environment Acts, and again, these are all examples from real life cases as well, we talk about it being severe or pervasive. I want to make clear, one incident can be enough to trigger that hostile housing environment claim. Or it could be cumulative, repeated, and unwanted. We'll have some examples later. And again, we're going to talk about a really big case we had in the Northern District of West Virginia that resulted from similar allegations. The last category here is retaliation. So retaliation, it seems pretty self-explanatory. So what happens if I am a victim of sexual harassment and I complain about that? Then if the landlord retaliates by moving to evict me from my housing, that in itself is a violation of the Fair Housing Act. So, for example, a harassing landlord evicts a tenant for refusing to engage in sexual acts or deciding to no longer continue to engage in sexual acts. That would be retaliation. And again, housing providers are always prohibited from retaliating against residents who complain about or report discrimination. Again, often in the form of eviction. So I talked to you a little bit earlier and I mentioned your immediate concerns. I'm going to hammer that home again today. If you are the victim of sexual harassment in housing and you are subject to these unwanted advances, the first priority should always be safety. Call your law enforcement. Get a temporary restraining order or a civil protective order. There are shelters available and other accommodations for you to go to. But the main thing is get yourself out of that situation. We don't want harm to come to anyone. Eviction proceedings. When I practiced here in the Eastern Panhandle, I did a lot of eviction proceedings for tenants and for landlords. And, I'm pretty familiar with the process, which in essence is if there's a violation of a lease, you can file a petition for wrongful occupation and have a hearing within 10 days. Now, if you're a tenant and you receive that petition for wrongful occupation, your first priority under those 10 days is to try to figure out where your family's going to go. How am I going to get money? Should I have an attorney? And getting there can be, and then ultimately getting there before the court in a very rushed time period can be difficult. But you may want to consider raising sexual harassment if you've been subject to it during your tenancy. I know at least when I was here, the magistrate judges were pretty, sympathetic to a lot of my clients, and so you may want to consider raising that. Now, it doesn't mean you're going to win the case based on it, but you at least have some form of a record as we go forward. And of course, you can always file a complaint with the Housing Authority. So again, let's talk a little bit again. I'm going to talk about this a couple more slides as well, the options for civil rights enforcement. I've talked to you that you can have private enforcement, meaning you can file your own complaint on your own behalf in federal court or in state courts as well. Again, you can make a complaint to HUD or any state or local agency. And again, we're here, the Department of Justice Civil Rights Division team and the Northern District of West Virginia Civil Rights team, with that information Bill put on before and what I showed you through the form as well. HUD again has an initiative to prevent sexual harassment in housing. And again, this is just a suggestion, but we strongly suggest that anyone who's experienced sexual harassment in housing file a complaint with HUD within 1 year. File that complaint with HUD, that's how it gets to our office. We have to do these individual rights complaints from referral through HUD. That's how it gets to us. Now, once you file that complaint with HUD, it'll preserve your individual rights to bring an action later. And also, again, there's no guarantee the DOJ will be able to investigate or ultimately file a lawsuit against a harasser, but the important thing is to get that complaint out there. And there's the HUD contact information. Also, you can see the numbers there that you can speak with the HUD intake specialist. I want to talk to you about a case that we're very proud of here in the Northern District of West Virginia. And it really took a lot of time, and when you hear about it, I think you'll understand why. So in 2015, our office here in the Northern District of West Virginia settled a sexual harassment lawsuit against Morgantown, West Virginia landlords. And the lawsuit arose when 4 female tenants filed complaints about a landlord with the Department of Housing and Urban Development, which referred the complaints to our office, like we talked about before. So this will show you how this mechanics works a bit. After conducting an investigation, the department filed this lawsuit back in March of 2016, alleging the landlord had sexually harassed multiple female residents and prospective residents from at least July 2006 through July 2015. And as you'll see, this is up here as a press release. I'm not expecting you to read it. I'm going to summarize it here for you. But the defendants ended up agreeing to pay $600,000 in monetary damages and civil penalties. It resulted in the landlord transferring ownership or management of these properties to someone else and actually relinquishing his role in managing any property. So this was a big win for everybody. Now, I bring up that number, that $600,000 number, for 2 reasons. As I mentioned, we can get damages through our affirmative civil enforcement practice, but we can also get civil penalties. And I'm going to talk to you a bit later about that in the context of the FCA. But just to make clear, $100,000 went to civil penalties. The other $500,000 went to these tenants who suffered this harassment. That's a major win for these tenants. And I can tell you that our office received a special commendation from HUD in 2022, because that is when we finally were able to issue all of the checks to all of the tenants that were there to receive money. And I'm going to tell you that oftentimes when someone from the United States Attorney's Office from the Northern District of West Virginia knocks on your door, that's probably not a good feeling sometimes. But in this case, it was. A lot of these tenants didn't even realize they were going to be receiving this money. And some of it I can't get into specifics, but I'm going to tell you this money was life-changing for some of these individuals. So again, it takes time to prosecute these cases. It takes time to recover, but when it does, it's so important that we do. And it's really an honor to be able to serve the community in doing that. So now I'm going to change a little bit to the False Claims Act. Just as a summary here, we talked about filing potentially suits on your own, filing a complaint with HUD, what type of actions when there's a pattern or practice of discrimination our office can handle directly. But now I'm going to turn to fraud a little bit. And I'm going to talk to you about the False Claims Act history. Now, I will note in 2019, there was a memorandum of understanding issued between HUD and the Department of Justice regarding use of the False Claims Act for Fair Housing Act cases. I won't get into the intricacies of that. I will say the avenue is still available, but there are some twists and turns there you'll have to go through. But I do want to talk to you a bit about the False Claims Act because it is interesting, and I use it a lot in my practice. So the False Claims Act was enacted in 1863 at President Lincoln's request to combat fraud against the Union Army by unscrupulous contractors and ruthless profiteers. So what was going on? There was rampant profiteering against the Union Army. They were supplying troops with bullets filled with sawdust, rifle barrels caked with rust, and other poor quality supplies. And in the case I'm citing here from California back in 1989, they quote some of the findings from the Fortunes of War, 29 Harper's Monthly Magazine. I thought I'd read it here. It's pretty interesting. For sugar, the government often got sand. For coffee, rye. For leather, something no better than brown paper. For sound horses and mules, spaven beasts and dying donkeys. And for serviceable muskets and pistols, the experimental failures of sanguine inventors, or the refuse of shops and foreign armies. So again, if you think about that, 1863 is when the False Claims Act first came into existence. And it was designed, again, to protect against fraud. Now, since the 1860s, the False Claims Act has been the principal tool used by the United States to fight fraud involving government funds. It's been updated and modified, as you can imagine, many, many times throughout to increase the use of government contracting contractors in the realm of healthcare fraud, and again, in insurance and loan guarantees and grants. I'm going to tell you, in my practice, we use the False Claims Act every single day. So think about that. We have an act that originated in 1860 because of rampant fraud resulting from the Civil War, and today we are still using it. It is our primary tool to fight fraud. And pursuant to the Fair Housing Act, there is obviously going to be fraud in government funds in housing, and so we use that tool as well to combat that in the realm of housing. So, given the significant federal interest and investment in housing programs, the False Claims Act has been a major enforcement tool in the housing area. So, FHA residential mortgage insurance, VA mortgage assistance, the USDA's Rural Development Housing Program, HUD Section 8. You're going to see a lot of fraud cases. I'm going to cite you recently, within the last 2 years, regarding Section 8 fraud. The FHA's residential nursing home and apartments programs, and VA supportive housing, and government-backed purchase of mortgages and mortgage-backed securities. I will note also with mortgage insurance, the Equal Credit Opportunity Act does apply to that as well and prohibits discrimination. I'm not going to talk about that today. Didn't have enough time to fit that in, but we're going to, again, focus just on the FHA. I mentioned that it was overhauled many times since it was enacted in the 1860s. In 1986, there was a big one, and I want to talk about that again, and that allowed to strengthen the public-private partnership at its core that allows for the public sector and the private sector to combat fraud. So in that case, it increased awards to whistleblowers known as relators, increased ability of relators to recover damages, and increased actually the damages and penalties. And all of these are designed to provide incentives for individuals with information to come forward. Whistleblowers, or in key tam actions, sometimes referred as relators. And again, the False Claims Act is designed to redress fraud involving federal funds. Importantly, this is a civil, again, I'm in the civil division, this is a civil statute, and so it does not require proof beyond a reasonable doubt. You'll hear that a lot, and I'm sure Jared and Sarah may bring that up as well, as they're in the criminal division. Ours is a lesser standard here in the civil division, and so it does not require proof of intentional wrongdoing, and it provides for the recovery of treble damages and penalties for each false claim. I'm going to talk to you a bit about that in regards to the Fair Housing Act. And again, like I said before, it's a civil statute that only requires proof by preponderance of the evidence. Whenever you bring up the False Claims Act, you're going to hear the phrase QUETAM. There's different ways to pronounce it. Some people say QUETAM. I say QUETAM. And it involves whistleblowers, sometimes called relators, and it allows them to file a complaint under seal pursuant to 31 U.S.C. 3730. And I'm not going to get into the in-depth mechanics of that. There's another presentation I give if you want to hear that. I'm sure it'll be advertised at some point. But just in essence, what it does is allow someone who's a whistleblower who may have witnessed discrimination or fraud regarding these housing monies, federal government monies, to come forward on their own and file a complaint. You have to do it with an attorney, but file a complaint under seal that is protected from public view to allow the Department of Justice to go in and investigate those claims of fraud. So the whistleblower provides the DOJ also with additional information that relate to a disclosure of all material evidence and information bearing on the matter. Once someone files a QUETAM complaint, it comes to our office, it comes to me. We start the investigation period. It's initially a 60-day period to investigate those claims. And we always, this isn't a Department of Justice requirement, but our office does make it a practice to meet with every single relator and their counsel to discuss their claims. Again, we want to, promote people coming and acting as a relator if necessary and reporting these acts. And so thereafter, after we do our investigation, we determine whether or not we want to intervene in the action. And if we do intervene, we take over and prosecute that action like it was our own. If the United States declines to intervene in the action, the relator can pursue it on their own or dismiss it voluntarily. So the reason why I bring all this up is if you are a witness to housing fraud or any type of fraud and you file a QUETAM complaint, you as the whistleblower or the relator are entitled to 15 to 25% of the proceeds of an action if the United States intervenes and reaches a settlement or judgment, or between 25 to 30% if the United States declines to intervene. Whistleblowers or relators are also entitled to reasonable attorney's fees, costs, and expenses if an action is successful. Now, again, I've been throwing a lot at you today. I understand that in regards to how to navigate the FHA and file certain complaints. I also am talking to you about QUETAMs and FCA. I want to make something very clear, though, and this has nothing to do with Fair Housing Act in general, but we can, in our office, prosecute fraud on its own. So, again, whether you're going to act as a relator or not, you can always call our office through the fraud tip line if you have any evidence of fraud that you would like to report. Under the False Claims Act, the pretty broad definitions of everything. Persons can include individuals, corporations, including municipal corporation, localities, and government entities. But there are some caveats on suing the states. A claim is described very, very broadly under the False Claims Act. And it really is any request for government money or property that include bills or invoices, claims by healthcare providers, grant applications, loan applications, claims for insurance benefits such as FHA and mortgage insurance, and claims for reimbursement of federal funding, such as Section 8 housing vouchers. So as you can see here, there are a lot of housing ability to pursue housing fraud regarding housing government monies. Keep moving here. So I'll give you some examples of some Section 8 program False Claims Act cases. In the Coleman versus Hernandez case, it was improper acceptance of Section 8 side payments constituted a violation of the False Claims Act. So in Coleman, a tenant was eligible for Section 8 rent subsidy, entered into a rental agreement with the landlord, fixing the tenant's total rent at $1,550 per month. The housing authority approved the rental agreement, which provided that the housing authority would pay the landlord $1,530 per month, and the tenant would pay $20 per month. But pursuant to the Section 8 rules, the landlord was prohibited from charging the tenant any additional payment. So in Coleman, the landlord charged the tenant an additional rent payment of $60 on 6 separate occasions, and the court held that these requests for side payments constituted 6 separate false claims under the FCA. And the reason why I bring this example up is I'm going to talk to you a little bit about how damages are calculated under the False Claims Act, and as you'll see, those damages can get up there pretty quickly. Courts have consistently concluded that liability arises under the False Claims Act when a Section 8 landlord charges a Section 8 tenant more than the agreed upon amount of rent, or charges a tenant side payments not included in the Section 8 housing agreement. Accepting Section 8 funds under the false premise that a landlord will make utility payments can also similarly give rise to liability under the False Claims Act. Also, falsely certifying the eligibility or suitability of a rental unit can also give rise to liability under the False Claims Act in regards to housing. Materiality is another element we have to prove whenever we have a False Claims Act claim. And material under the False Claims Act is defined as having the tendency to influence or being capable of influencing the payment of money or property. And you'll see the Escobar case cited there. That is one of the cases that's consistently cited post-2016 by both the DOJ and defendants as well. Courts have consistently concluded that overcharging Section 8 tenants and charging improper side payments can satisfy the materiality requirement. Falsely certifying the eligibility and suitability of the rental unit can similarly be material under the False Claims Act. And accepting Section 8 funds under the false premise that a landlord will make utility payments can similarly give rise to liability under the False Claims Act. Scienter, which is knowledge under the False Claims Act, is defined as actual knowledge, reckless disregard, or deliberate ignorance. Again, I point this out. We're in a civil statute here. We don't have to prove anything beyond a reasonable doubt. And also, specific intent is explicitly not required under the False Claims Act. So I mentioned this before. False Claims Act provides for treble damages. So, for instance, if I have damages regarding government funds in the amount of $100,000. For my damages portion, I can collect 3 times that amount, which would be $300,000. Treble damages are mandatory. The court has no discretion to reduce them, and they are outside the presence of the knowledge of the jury. Government damages under the False Claims Act are the amount it would have paid if statements or claims had been truthful. Damages are not required. I will note that. You can't have liability and collect penalties even if there's no damages, and I'll talk to you about penalties, I think, on the next slide here. One legal issue that came up in regards to Section 8 is in a Section 8 side payment case, the question was raised, are the damages the amount of impermissible rent collected from the tenant, which in our previous example was the $60 on a few occasions, or the entire amount of federal funding paid, which would be the $1,500, $1,500, and $320 figure I talked about before. The courts have most often held that because all federal funding was conditioned on not abusing the program by accepting improper side payments, damages were appropriately measured by the full amount of Section 8 funding rather than merely the amount of the additional side payments. So we also have a damages range that goes between $5,000 and $10,000, but obviously with inflation, subject to inflations, that amount is now between $11,803 to $23,607 to attach to each violation of the False Claims Act. So as you can imagine, if you have 10 violations of the False Claims Act, you're going to have a potential civil damages penalty in 2022 of between $11,803 to $23,607. So again, those numbers with your treble damages and your potential civil penalties can jump up there pretty quickly. And remember, if you are a relator or whistleblower bringing a key TAM action, you'll get a percentage of those damages and penalties, whether we intervene or not, if you pursue the case on your own. Again, relators share 15 to 25% for intervened cases and 25 to 30% for declined cases, which again is based on the full amount of recovery. The False Claims Act is an incredibly powerful enforcement and remedial tool in Section 8 overpayment cases. Again, here's an example. A landlord improperly collects $50 utility fee side payments in addition per month beyond agreed upon Section 8 rent on a $1,000 a month apartment for 12 months. So tenant was overcharged $600 in total, which would be $50 times 12 months. But under the False Claims Single Act damages, because they were receiving $1,000 per month pursuant to the Section 8 federal funding, that single damages amount jumps up to $12,000. So the total False Claims Act judgment would result in about $315,972, which is 3 times $12,000 is $36,000 in treble damages. Plus, for each violation, including the $300,000 in penalties, which is the figure I talked to you about before for the civil penalties for each act. Again, if your relator would be entitled to up to $78,000, assuming a 25% share, plus the full amount of reasonable attorney's fees. Statute of limitations for a False Claims Act claim is typically 6 years from the payment of the claim for federal funding. In some cases, you can go back 10 years, so long as suit is filed within 3 years of the DOJ having knowledge of the facts and material to the writer of action, and that applies to us as well. I am almost out of time here, but I'm going to finish up very quickly citing some Section 8 DOJ cases. United States versus Willis v. May Ava Karst Properties, which was a 2020 case, $150,000 settlement for collecting excess rent from Section 8 tenants. And neat fact about this, the University of Michigan Law School Clinic represented the relator, the Section 8 tenant. U.S. versus Goodfish, another 2020 case, filed a suit under the FCA against landlord for charging higher rents for Section 8 rental units. Ling versus City of Los Angeles, a $3.1 million FCA settlement against City Housing Authority for violating accessibility and development of affordable housing. And U.S. versus Ortiz, which was $15,502 FCA settlements against the landlord for charging improper water utilities and other fees to Section 8 housing, so Section 8 tenant. I have a minute or so left if anyone has any questions. Otherwise, I'll turn it over to Bill. Yes?
I'm understanding the falsifying and fraud way back when you mentioned profiteering. And certainly within COVID and a lot of other things, there's a lot of people feeling
Sure.
companies, gas, food, whatever, has been profiteering versus just increasing reasonable cost due to production. Comment on profiteering?
Absolutely, and that's a very good question. And since Bill has been our U.S. attorney, he's put a real emphasis on healthcare fraud. We formed the Mountaineer Healthcare Fraud Strike Force to combat these very issues. COVID fraud, in my opinion, is going to be, we're going to have those cases for years to come, in a variety of different things. Improper testing, upcoding. You go to get a COVID test, they test you for a couple things or more things you're not supposed to. Falsification of COVID tests, things of that nature. So that is a very, very important area that we're focusing on right now. The other area we're focusing on is PPP loans, Payment for Protection Act program, those loans. And those are the loans that you applied for and you'll get based on your income and things like that. We're finding across the nation you'll be reading things about PPP loan fraud. And we have also got our own task force, in essence, in our office to address that. So I encourage anyone that has any information about COVID fraud or PPP loan fraud, contact our office. We'll sit down and talk with you. We're very interested in it. As you can imagine, especially in the PPP loan fraud world, there's $1 trillion of federal money at issue. And so I think a grand total, we came up with 16,000 PPP loans in the Northern District of West Virginia alone. So we have been working double time to sort through those and identify potential fraud and work with various agencies. So yeah, you're right on point. COVID-19 fraud is going to be the next wave of fraud, and our office is, I think, ahead of the curve on that as we are now. Thank you. Any other questions? Yes?
I was curious, is there any mechanism to prevent an individual who has been convicted of one of these civil liberty crimes, particularly a landlord, from re-entering into a landlord relationship?
Well, yes. you saw in the consent decree, one of the cases was resolved pursuant to consent decree. Oftentimes there will be a provision that says, hey, you can't manage landlords anymore going forward or for a set period of time. But absolutely, that is one of our extraordinary remedies that we have the ability to enter into with a landlord who's committing violations like that. Absolutely. Yes?
Yeah, going back to fair housing topics, and we talk about sexual discrimination and sexual harassment. Well, how does the LGBTQ community fit into that sexual discrimination and harassment?
Well, anybody at all who's for any reason who's experiencing sexual harassment, regardless of their sexual orientation, you can obviously pursue sexual harassment. Sexual orientation is not yet a protected class under the FHA. I assume at some point there's going to be legislation that makes that happen. But I want to be very, very clear. Just because sexual orientation is not a protected class, that does not mean you cannot suffer sexual harassment. So yes, you are protected to that extent. Every person, every citizen in the United States, it should be free from sexual harassment in housing. All right, I think I'll turn it over to Bill. Thank you. Those were great questions.
Thank you so much, Chris. The case out of Morgantown that you mentioned is really interesting. Gary Walden, in addition to having to pay that $600,000 penalty, Mr. Walden was also prosecuted on criminal charges for sexual abuse, for conspiracy, and for burglary, and was sentenced to up to 10 years in prison. So the county prosecutor handled the criminal side of it. Our office handled the civil side of it. He was a landlord just using that position to gain access to victims. He was a sexual predator, and he used that to gain access, and he used it to obtain leverage over his tenants. So unfortunately, he's not the only example of that happening, and we want to hear about those kinds of things if the public is aware of it. All right, very excited to announce our next presenter. It's Annie Lewin, Director of Social Equity, Inclusion, and the Title IX Coordinator at Shepherd University. She coordinates efforts across campus to ensure equity in university programs and activities. She also manages the response and resolution for complaints of discrimination, harassment, and sexual misconduct. Annie also delivers campus-wide training to promote a culture based on mutual respect, dignity, and value for all members of the campus community. Annie earned her law degree from West Virginia University, and she's going to speak to us today about the evolution of Title IX over the last 50 years, focusing mainly on the response and prevention of sexual harassment in higher ed. She will also outline prevention tools that communities can use to empower students with agency and respect for the boundaries, humanity, and bodily autonomy of one another. Annie, the floor is yours.
Can you hear? Oh, hell, there. I'm not really a podium kind of person, so I guess I'll sit here. So my name is Annie Lewin, and I work here at Shepherd University as the Director of Social Equity, Inclusion, and Title IX Coordinator. And a lot of what I do is responding to complaints of harassment, discrimination, and violence. But another big piece is doing prevention education with all members of the campus community. So today I'm going to talk about Title IX in general, the background and the evolution and the legal landscape, and talk to you also about Shepherd's policies and procedures. And then I'm going to end to talk about prevention education and what we focus on training our students and our faculty and staff to try to get ahead of it and prevent it from happening before. So, Title IX is a federal civil rights law passed in 1972 as part of the Education Amendments, and that is the 37-word law that has evolved a whole lot since that time. But it says no person in the United States shall, on the basis of sex, be excluded from participation in, denied the benefits of, or subjected to discrimination under any education program or activity receiving federal financial assistance. And essentially what Title IX does is it protects all members of the campus community from gender or sex-based discrimination, harassment, and violence, as well as retaliation. And you heard a little bit about that in the prior discussion. And I'm going to talk a lot about retaliation because it is a huge piece, and it makes a big difference, and it's a big reason why people do not come forward and report. I wanted to just cover a couple other civil rights laws that apply in the educational context. So you have Title VI of the 1964 Civil Rights Act that covers race and national origin, and it's essentially the same language as Title IX, and it applies to recipients receiving federal funds. But sex was not included in the original 1964 Civil Rights Act, and so it was later included in the Education Amendments in 72. And so this is 2022, and Title IX actually turns 50 this year. Title IV covers race, sex, religion, and national origin, and basically says the Attorney General of a state can bring an action for any of those protected classes on a federal level. And then you have the Americans with Disabilities Act, passed in 1990 and updated in 2008, and Section 504 of the Rehabilitation Act of 1973 that cover and protect students from discrimination based on disability in the educational setting. And then Title IX in 1972. So essentially, at a minimum, under Title IX, institutions must designate a Title IX coordinator, disseminate a non-discrimination policy, so create and have that policy and disseminate it to all members of the campus community, and then adopt, publish, and distribute grievance procedures so that anybody that's experienced harassment, discrimination, or violence knows where to go to report that, what the outcomes look like, and how to resolve those complaints. It applies to activities both inside and outside of the classroom, and it applies to both public and private educational settings because of if there's any federal financial assistance received. So even private institutions of higher education, most students receive the FAFSA and receive federal assistance, so it applies to those institutions as well. So Title IX has very, very broad application, and it has evolved a lot since that 37-word that I showed you at the very beginning. And so it applies to gender equity in admissions, recruitment, and financial assistance in educational institutions. It applies to academics, and historically you saw exclusion based on gender, which is why, you had the enactment of Title IX, but then you saw even after that exclusion specifically in science, technology, engineering, and math areas. And today you actually see a higher rate of sexual harassment in science, technology, engineering, and math areas as well. It applies to athletics. So when I first started doing Title IX trainings about 6 years ago, that was really the public awareness was really connected Title IX to gender equity in athletics. Over the past 6 years, you've seen a lot more media attention and understanding of Title IX's protection around sexual harassment, specifically sexual assault, especially on college campuses across the country. And so it also applies to sexual misconduct, including harassment, violence, and exploitation, and that will be the focus of my discussion today around the evolution of Title IX. Also, it applies to gender identity expression and sexual orientation, and there's a little bit of contention around there, especially between federal guidance and executive initiatives and some state laws that have been passed recently. It applies to gender equity and disciplinary procedures, and as well as pregnancy and parenting status. And that is another area that I think is expanding, especially around awareness that students are protected based on pregnancy and parenting status. And we also see, and I'll talk about in a minute, in the new proposed regulations, enhanced protection in that area. And that's an area we're trying to grow awareness around as well, because we do see a lot of discrimination and students are not aware that they are protected. It applies to employment, and then again, retaliation, which I can't stress enough, to raise awareness around retaliation and the protection of that, to promote reporting. So it has evolved a lot since that original language, and it's enforced by the Department of Education Office for Civil Rights and the Department of Justice Civil Rights Division. And as I said, it turns 50 this year, and it's evolved through regulations, through federal guidance, and then through case law and judicial interpretation of especially what that language on the basis of sex, what does that mean? What is included under that? And so I'll just talk a little bit about historical, the case law. So in Cannon v. University of Chicago in 1979 was a case that determined that there was also a private right of action, that individuals could sue institutions of education to enforce the regulation of Title IX. And then Franklin v. Gwinnett Public Schools in 1992 said that it also includes sexual harassment, that you could bring an action. And then Gebser in 1998, the Supreme Court held that if an institution of education has actual knowledge of sexual harassment or misconduct or discrimination, and they act with deliberate indifference, then they could be held liable. And that was a quid pro quo case. So it was a teacher that was the offender, the harasser, and a student was experiencing the harassment. And then in the Davis v. Monroe County Board of Education in 1999 was the case that really went and discussed the application of hostile environment harassment. So it held that sexual harassment, including sexual violence, is a form of sex discrimination when it has the impact of denying or limiting an individual's access to programs and activities. And that was a case, that was the first case that was a student-on-student sexual harassment case. So institutions could actually be held liable for student-on-student sexual harassment, not just sexual harassment of a person with authority. And then you have all of the guidance that came from the Office for Civil Rights over the years. In 1997, there was sexual harassment guidance that helped institutions understand what was expected in response and prevention of sexual harassment. That was revised in 2001. And 2010, you've got the bullying and harassment guidance. And then 2011 was the sexual violence guidance that really was the first time that the federal government had an expectation and really was starting to hold institutions of education accountable, especially for response to sexual assault, specifically on college campuses. And they started to investigate universities and colleges, and it became, there was a lot of work put into, prevention and response, and a lot of, new positions were created, and colleges really started to tackle this issue and address it, and it became a big important topic in colleges and universities. And then 2013 there was pregnancy guidance. 2016 there was guidance around protection of transgender students, and then all of that guidance was basically rescinded in 2020 when you actually saw the Department of Education Office for Civil Rights go through the rulemaking process and issue the 2020 Title IX rules, and which changed a lot of, and that was May 2020, in the middle of the pandemic, and it was like, bam, here's these new rules. You got to update all of your policies, all of that. So that was a big, dramatic change in a lot of ways. And the focus of those was on sexual harassment in particular. But one of the changes was the prior guidance had maintained a constructive knowledge accountability for institutions of education. So if an institution knew or should have known that the sexual harassment was occurring, they were required to respond. Now, under Title IX, the new rules say that an institution is required to respond when an official with authority to take corrective action has actual knowledge. So it gets rid of the constructive knowledge. It also kind of narrowed the jurisdiction. It held that Title IX response was required when the institution had substantial control over the harasser and the context of the harassment. And so prior to 2020, and it's in colleges and universities, we were required to respond if there was an off-campus incident that occurred, like a sexual assault off campus, if it had an impact on an individual's access to education, if it was impacting them. And so that was part of our process. But now it was, you saw a lot of campuses creating two different policies. So you'd have your Title IX policy that would apply to incidents occurring on campus, or in a location where the institution had control over that location. And then you'd have the other sexual misconduct policy, because we would want to respond to incidents occurring off campus, but we had to do it in a different way. So a lot of institutions have these two different policies now. It also narrowed the definition for hostile environment sexual harassment, which I'll talk about in a minute. But prior to these 2020 rules, sexual harassment analysis for hostile environment was a severe or pervasive and persistent. And now it's severe and pervasive and persistent. And it also incorporated, which was a positive, the sexual assault, dating violence, domestic violence crimes under the Clery and the Violence Against Women Act as incorporated as a form of sexual harassment. It also kind of changed the reporting and complaint process because prior to this, we were responding to reports, but after the 2020 rules, it required that an individual have to file a formal complaint to initiate any type of grievance procedure, even if it was an informal resolution. So even if they wanted to go through an informal process, they have to file a formal complaint in writing to initiate any of that. And then it also really changed our disciplinary proceedings for resolving complaints in a formal capacity. We now were required to have a live hearing with cross-examination conducted by the advisor of the parties. And if the party did not have an advisor, we had to provide an advisor for them. So what happened there is it kind of created like a quasi courtroom type of situation where prior to these rules, students could speak for themselves, and we would usually limit through our policies the ability of the advisor to participate, although they could have an advisor throughout the whole process. Now it was requiring the advisor to conduct the cross-examination, and the students can't speak anymore in these formal hearings. And so the other piece of that is that if one of the parties had an attorney, that we would need to find an attorney or someone that works at the university that could conduct the cross-examination. And so we would have to train individuals at the university, employees, to be able to conduct cross-examination. So I just wanted to mention how Title IX and Title VII, although they both cover and protect discrimination based on sex, while Title IX is in the education context and Title VII is in the employment context, They're kind of at odds right now because of those new rules in the analysis to determine whether a hostile environment is created under Title VII. You look at, is it severe or pervasive and objectively offensive? And under Title IX, you have to do the analysis, and it would be, is it severe and pervasive in it? So as it stands right now, they're kind of at odds with one another, but that looks like it's going to be changing soon. I also wanted to mention the Bostock v. Clayton County case that happened in 2020, which was a Title VII case, and expanded the language. So Title VII from the 1964 Civil Rights Act protects from discrimination based on race, religion, sex, and national origin in the employment context. And this case held that that on the basis of sex discrimination under Title VII, that language covers discrimination based on gender identity and sexual orientation in employment. And historically, they have aligned with one another. And the Biden administration issued an executive order at the beginning of 2021 outlining that this case also applies to analysis of Title IX. But there's been a lot of backlash against that, and some cases that have held that that's not the case. So there's some clash between the federal level and the state level in this area. So brings us to 2022. As I said, Title IX turns 50 this year, and recently in June, the Department of Education issued the proposed regulations that will kind of restore some of the way that we did things prior to the 2020 rules. Not all the way, but some of the things that are restored are going to be the hostile environment analysis and protections back to the severe or pervasive. And it will also include protections for gender identity and sexual orientation, and so in those two ways, it'll align again with the language in the and from Title VII and Title IX. And it will also it also kind of expands the pregnancy protection, and it includes this language that says pregnancy or related conditions, and also expands the definition of parental status, so that it will protect more students that are parents and employees, students and employees. It also clearly states that there's protection for employees as well. It also restores the constructive knowledge test, so that it goes back to universities having an obligation to respond if they knew or should have known that the sexual harassment or discrimination was occurring. It removes the cross-examination requirement, and the role of the advisor changes back, and it allows also for a single investigator model to resolve complaints as it did before. So now I'm transitioning to kind of understanding our policies and procedures and the training that we present for the campus community at Shepherd. So sexual harassment is unwelcome conduct of a sexual nature that is sex or gender based, and it can fall into one of these categories. Quid pro quo is based on a power differential, and literally means this for that. So you have a person in a position of power. It could be a professor and a student, or an employer and employee, and indirectly or directly the person in authority requests sexual favors in return for an A or anything else that could be in return for the favor. And then you have the hostile environment, which is that severe or pervasive and objectively offensive analysis that interferes with a person's ability to access educational programs or activities. Sexual assault, dating violence, and stalking are now codified as forms of sexual harassment under Title IX. And then again, retaliation is a form of discrimination. And there was a Supreme Court case, I think 2003, that specifically addressed retaliation under Title IX, the Jackson case. And it held also that you don't have to be the person experiencing the harassment to be protected from retaliation. If you're reporting that it's occurring, then you are also protected. So some of our policies here at Shepherd, which we incorporate all of those definitions from the Violence Against Women Act and the Clery Act, are outlined here. Our sexual harassment is broken into two categories: the quid pro quo and the hostile environment. Our sexual assault also is broken into two categories: non-consensual sexual contact, which is intentional contact of a sexual body part, and also aligns with the fondling definition from the Clery Act, and then non-consensual sexual intercourse, which aligns also with the definition of rape from the Clery Act and the Violence Against Women Act. Dating and domestic violence are, physical violence and threats of violence that occur within an intimate relationship and intimate partnership. And we also try to, train the campus community on understanding that all of these different forms of misconduct can occur within a relationship. And then stalking is engaging in a course of conduct directed at a person that would make that person fear for their safety or suffer substantial emotional distress. And we do see a lot of stalking occurring, and a lot of times it's downplayed until it escalates. And so we ask for any form of misconduct. We try to train our campus community on making sure that they're documenting the situation. But what we run into is it can be an issue sometimes, especially for students, when their communication, a lot of the communication is through social media, and some of these apps like delete the messages right away, right? And so like Snapchat, for instance, if anyone's familiar with that. So I can't even tell you how many times I've had someone, report an incident and tell me about a communication, and I say, do you have that documented? Do you have that communication? Oh no, it's deleted. It's gone. So that's something we try to make students and other campus community members aware of, making sure that they're documenting, even if, as I said, it's downplayed a lot until it escalates. So even if they don't think it's that serious, to start to document that. And we're also kind of starting initiatives to try to train around digital awareness, because those are areas that are growing. Harassment, online harassment, and digital abuse is an area, and even digital incivility. And so trying to train and make everyone aware about that issue. Gender-based harassment is harassment based on gender identity or sexual orientation or nonconformity with gender stereotypes. And then sexual exploitation is taking abusive, non-consensual advantage of another for the advantage of anyone other than the person being exploited. And a lot of times what we see here is also digital sharing. It could be consensual acts that happen, but the sharing of that is not consensual. And again, retaliation. I like this visual that I show to the campus community, because a lot of times there are questions posed of, why are institutions of education responding to crimes of violence like sexual assault, stalking, and dating, domestic violence? Well, they're not just crimes of violence. They're also forms of discrimination and are protected under civil rights law. So you have overarching discrimination, Title IX and also Title VII come under sex-based discrimination. Sexual harassment is a form of that when it interferes with access. And then, sexual misconduct, including non-consensual sexual intercourse, is a form of that, and it's a form of discrimination. So I think it's helpful for people to understand. When we do a hostile environment analysis to determine if the harassment rises to the level that would be a form of discrimination, we're looking at, is it sufficiently severe and or, depending, persistent and pervasive, and objectively offensive, so much so that it has an impact or denies access to educational opportunities or programs. We look at the frequency. Is it physically threatening or humiliating? The severity. Physical conduct is going to rise to that level much quicker than verbal conduct. With verbal conduct, you're going to look at more, is there a persistent or pervasive element present? And then again, you're still going to look at the identity and the context and the relationship of the harasser and the person experiencing the harassment. Is there a power dynamic there? And then the overall context to determine, does it rise to that level of a hostile environment? So retaliation, again, I can't stress how important it is to raise awareness and make sure that individuals are protected from retaliation, because the power dynamics that play out really prevent reporting, and they prevent us from resolving, and they impact an entire community. Intimidation, threats, or coercion or discrimination that's intended to interfere with the rights secured by state or federal anti-discrimination laws. And this is a quote, I think it's from a Supreme Court case, but I can't remember exactly right now. But I really like it because I think it really rings true. Retaliation and the fear of retaliation becomes a potent weapon used to maintain the power structure within an institution, and not just within an institution, but the power structure with any even social groups or certain communities, employment contexts. It's really used to maintain power structure and keep things the way they are and keep people silent. I wanted to mention the Clery Act and the Violence Against Women Act as well, because they work really in conjunction with Title IX and they all intersect. The Jeannie Clery Act, Disclosure of Campus Security Policy and Campus Crime Statistics, was passed in 1990. It's a consumer protection law, so that when someone's looking at different institutions of education, higher education, they can go right onto their website. They can see all the crimes that occur on campus, how many crimes and when they've occurred and what they are. And every year we issue an annual security report where we have all of those crimes listed over the past 3 years. And we have all of our policies and procedures for resolving complaints of sexual assault, harassment, and all those forms of interpersonal violence that I went over. And it also ensures safety and requires prevention measures. The Violence Against Women Act was passed in 1993, and it provides resources for legal and community prevention and response of stalking, dating violence, domestic violence, sexual assault. It was reauthorized in 2013, and that reauthorization had a huge portion of that was known as the Clery Amendments to the Violence Against Women Act, and it really impacted higher education and required us to have policies and procedures to resolve those complaints and to have those outlined and distributed to the campus community. It also required us to engage in ongoing and prevention and education measures. So we're required to provide training for all incoming students, faculty, and staff, which I do every year, and also provide resources to those that are reporting. It was just reauthorized in 2022, and it's pretty exciting. It includes some other initiatives around economic abuse and technological abuse. Like I said, technological abuse is a growing area that a lot of people are not understanding the full force of what's happening. And it also includes funding for prevention and restorative practices. And we are also in the process of a restorative justice initiative here. So reviewing the laws, I like this as well, because it kind of helps to understand each of these. They intersect, but Title IX is a civil rights law, applies to athletics, verbal harassment, and all of those. Clery is crime reporting and transparency. And then VAWA is where they intersect, the Violence Against Women Act, for crimes of sexual violence. And I like to think of Title IX as that ensuring access. Violence Against Women Act is resources, and Clery is transparency. And I think those three things are huge and important and intersect to ensure that we are responding and preventing all forms of violence, harassment, and discrimination. So resources, transparency, transparency and access. We did a campus climate survey a couple years ago here, and we found that 1 in 6 women and 1 in 12 men had experienced some form of unwanted sexual contact in their 4 years of college here. It's a little bit lower than the national stats for women and a little bit higher for men. And we also found some positive things. Over almost 92% of our students surveyed stated that they feel safe on campus. That's still 8% that don't. Over 80% were aware and understood our policies and procedures for handling sexual violence. I like to highlight this one because over almost 95% of the incidents of sexual violence occurred by someone the victim personally knew. I like to highlight that because under the Clery Act, if there's an incident that occurs on campus, sometimes we have to, and there's an ongoing threat, sometimes we have to issue a statement to the campus saying that a sexual assault occurred on campus. And when we do that, a lot of times the campus community gets very fearful and kind of jumps to this idea that there's someone jumping out of the bushes. But really, in reality, it's a lot of times an acquaintance situation. We also found that we have a particularly high red zone, and the red zone is the first 6 to 9 weeks of classes where individuals are at higher risk for sexual violence here in comparison with other schools in West Virginia that did the survey, which was mostly every other school other than WVU. We also found that we had higher education around consent, which was really positive. I wanted to mention marginalized populations and violence because we see this on our campus, and then you see this nationally, and these are national statistics, but that are higher risk for sexual violence. So you see some of these statistics: almost 50% of multiracial women, almost 75% of bisexual women experience sexual violence. 45.6% of American Indian Alaska Native, 83% of women with developmental disabilities. That's just huge. 47% of transgender individuals, 52% trans women of color, and then 76% of incarcerated women have experienced child abuse by the age of 13. I think this is an interesting one too, because you hear sometimes about those school to prison pipeline. There's also a sexual abuse to prison pipeline. I think it would be interesting to know how many incarcerated men had also experienced sexual violence as children, because we probably don't have those statistics, and it's probably also very high. So it leads to impacts your entire life after that. We have mechanisms put in place at Shepherd. We never changed our policy around responsible employees and their requirement to report, even though the rules changed and we didn't have to keep those policies in place, but we still have a policy that says all employees at Shepherd are responsible, and they're responsible to report if they have any knowledge of sexual misconduct, discrimination, or violence, and report all that information to the Title IX coordinator. But we like to reframe the reporting requirement because it can be it can create a lot of fear and discomfort. So we reframe it, especially when I do trainings for residents' life, for the RAs and the hall directors, and it's not like, now that you told me this, I have to go tell someone. I have to go tell my supervisor. I have to go tell these people. It's more like, I'm going to listen to you, provide you support. I'm not going to ask you questions or investigate. I'm going to provide resources, let you know you're not alone, and I'm going to connect you to a team of people that we have on campus and off campus that are going to ensure your access to education and ensure that you have all of the resources that you need to be successful and continue in your education. And that's what I'm going to do now, is I'm going to connect you to them. We provide supportive measures in our response. We can send out Handle with Care to professors. We can change living or working environments, class schedules, modify anything like that to ensure that we're eliminating that hostile environment. We can connect to off-campus counseling, or on campus. We have counseling here. And then we also have a really, really wonderful relationship with our local anti-violence organization, the Eastern Panhandle Empowerment Center. We work with them, do trainings with them, do programs, events. They come on campus, and then we also work with them in our response. We can do no contact orders, academic accommodations, security assistance. Another big important piece is amnesty policies, so that students that are reporting know that they aren't going to get in trouble for alcohol use or things like that if that happened during the incident, so that they're not fearful of getting in trouble when they're reporting. This is our response and resolution. We have a duty to stop the harassment or violence, eliminate any hostile environment that may have occurred, prevent it from happening in the future, and remedy the effects. So whenever an incident's reported, we immediately reach out and provide supportive measures and resources. We do an assessment to consider the nature of the report, the safety of the individuals involved, the safety of the community as a whole, and how the individual who experienced the harassment would like to move forward. We have informal and formal resolution options. A formal resolution goes through a formal investigation that will go to a formal hearing board to determine whether or not a policy has been violated and if the individual is responsible and what the sanctions will be. Informal resolutions can be tailored to the situation, and depending on the situation, can include a no contact order. They could be include mediation, arbitration, or restorative justice or restorative processes. But there are alternative dispute options, and they're community-based and remedies-based approaches designed to eliminate the hostile environment and make sure that we're preventing it from happening in the future. So there's a consistent focus on prevention. And some of the foundations of restorative justice. As I said, we have a restorative justice initiative. We're trying to make that part of the campus culture. And these are some of the foundations. Respect, there has to be accountability, healing for individuals and as the community as a whole, and this focus on empathy. And so I'm going to transition here to our prevention education efforts and a lot of the topics that we talk to the campus community about to ensure that we're preventing harassment, violence, and discrimination before it happens. So we know that when we create a culture of respect on our campus, when we treat each other with mutual respect and dignity, we build our capacity for empathy, and we value the humanity of all individuals, that we see incidents of violence go down. And not just that, but success. Every member of the campus community is more successful when we focus on this culture of respect. We also talk a lot about language, even though it's often downplayed, and how important it is because it's at the root of the culture we create, and words have so much, they can have such an impact on a community and the culture. But as I said, they're often downplayed. And so we try to empower students to speak up when they hear disrespectful, degrading, or dehumanizing language, to try to create this culture, because we know that if it's spoken into an environment, it changes the environment. And if it's allowed to continue, some people in a community, not everyone, but some will think it's okay to take it a step further and act out those in a physical way. We also talk about the difference between impact versus intent. So understanding that even, a lot of times when students or anyone tries to interrupt, if they hear, sexist or racist or just disrespectful or dehumanizing language, that a lot of times there's this defensive jump to, I didn't mean this or that, it wasn't my intent, it was just a joke, and trying to understand that regardless of the intent, the impact of the words or the impact of the actions is what we should focus on moving forward. How can we look at that and change that moving forward to create a more inclusive, respectful environment? Because we know that if we can interrupt the language at the base, we topple the whole pyramid. But when we allow that to continue, when we allow that to exist and not interrupt at this level, we know we see higher acts of bias, we see dehumanization, bullying, we see increased rates of systemic discrimination, economic, educational, employment, and then you also see higher rates of physical violence, assault. At the top it says genocide, which some might seem dramatic, but you've seen historically and even currently globally that when it's allowed to go uninterrupted, that you see that acceleration of violence in some communities. Another huge thing, am I running out of time? Okay. That we really focus on training our students and campus community around is understanding boundaries, because that's not something that they learn growing up. They don't really learn about boundaries, what they are, knowing their own boundaries, and then communicating those boundaries. So we try to help them understand. And I can tell you right now, students coming into college right now have a lot less tools of understanding how social interaction, communication, boundaries, all of that, after COVID, because they were struggling before COVID. So understanding what they are, the limits, what's okay and what's not okay, recognizing that it's difficult. It's difficult to even know your own boundaries, and then even more difficult to communicate those because of, fear. A lot of times it's fear of what will the reaction be, or, wanting to be included and to be liked even. So trying to know what the boundaries are for themselves and then be able to communicate those against the barriers, and then to also, normalize boundaries and to empower each other to do that. It's just really huge. It seems simple, but it's a game changer. And so these are some of the tips we go over for, setting boundaries and knowing that you can do that and not to feel guilty or selfish about that. And it takes time. So like I said, students aren't learning a lot of times what boundaries are or how to know them or communicate them when they're growing up. And so practicing that and providing a system of people around you that can respect and empower you to do that is really important. And then consent is another big piece. And essentially, communication of boundaries is really what consent is. So if they can get boundaries, they can get consent. And these are all the elements of consent. So active mutual choice, clear and unambiguous, this ongoing communication. In our campus climate survey, we did find a little bit higher rate of coercion here. So we've really focused on understanding what coercion is well, and intimidation, and understanding that you can get to a yes without actually getting consent. So we talk a lot about this consent continuum, and we also talk to them about, where did they first learn about consent? Where did they first learn about sex? And I do trainings with all of the student athletes. I do trainings with all the incoming students. And I can tell you, when I ask them, where did you learn about consent? A lot of times it's at Shepherd. My first time learning about consent is at orientation here at Shepherd. And that is way too late to have the conversation around consent. And so they don't know boundaries, and they don't know consent, and those are things they need to practice to understand. And then also understanding where they're learning about sex is really very important, because they're not getting sex education from their parents, and a lot of times they're not getting it in school. The average age that an individual sees sexually explicit material online today is 8 years old. So we know that they're learning about unhealthy intimacy online, and not in school, and not from their parents. So sex education is really just very, very huge piece of it. So I wanted to talk a little bit about this book. I think I'm almost out of time. And it was a really important book that we've used a lot in the trainings. It came out in 2019, I think, or 2020. And these authors did a lot of research. They're both professors at Columbia. They did a lot of research around understanding students, college students specifically. They interviewed tons of college students. They found that they could define consent, effective consent, but when they asked them if they were using it and practicing it, they weren't actually using it. So there's a disconnect between knowing it and learning it at orientation. Oh yeah, these are all the elements, but then actually using it. And they also found that there's the three kind of overarching topics, and sexual citizenship is kind of this concept that if we raised our youth and to understand themselves as full sexual citizens with rights and autonomy, that deserve boundaries to be respected, and understand the boundaries and respect those of others, and see everyone else as a full sexual citizen, that we would greatly reduce the risk of sexual assault and harm on campus. The other ideas that they talk about are sexual projects, which is the why of students engaging in sexual interactions and how that evolves over time. And at the beginning of school, at the beginning when they first start college, they're engaging in those interactions more for like they want to lose their virginity, or they want to gain experience, or maybe even for status reasons. And as they get older, which makes sense, that they're engaging in those interactions more because they want to have an emotional connection to someone. And so there's an increased risk of harm at the beginning, because the reason, the why of why they're engaging in those sexual interactions is disconnected from the humanity of the other person. And so when you don't see someone as a full human being, you're more likely to engage in acts that might cause harm to them, intentional or unintentional. Stand Up, Don't Stand By is our bystander intervention program, where we empower the campus community to stand up and speak up when they hear disrespectful, degrading language, when they see something, to say something. And these are some of the tools to intervene. They can do it directly. They can delegate to someone with more authority, or they can, distract. And our classic example of that is if they're at a party and they see two people really intoxicated going upstairs, then they could say something like, "Your car is getting towed," or something like that. So to just interrupt it. It doesn't really get to the root or the source of what's going on, but at least it prevents it from happening. In our climate survey, we found that students are more likely to intervene in those situations, or if they see a physical altercation, but when they hear that language that's disrespectful or degrading, they're less likely to speak up and say something. They're afraid. So we don't have to do everything, but if everyone does something, it makes a big change. And these are some resources we provide to be an effective bystander or ally, to engage in campus resources, attend awareness and events. We have events and programs all throughout the year. Empower survivors to tell their stories, recognizing and respecting boundaries and consent, working to create environments where harassment is unacceptable. Respect, the culture of respect is huge. Educating ourselves first and foremost, and then speaking up. So prevention is really the key in my view. It's not awareness, it's not response, it's not compliance. It's challenging. It takes a lot of time and energy and conversations, and you have to keep going and reminding and doing, but it's worth it. And that's all I have. Does anybody have any questions?
So is the culture of respect a mandatory course here at Shepherd for all new students?
Yes, I created an online course. I created an online course using the Articulate software. I don't know if anyone's familiar with that, but we were able to use videos of like student voices and other voices, and it's an interactive course that every incoming student has to complete, and so does every incoming employee. And then we also do orientation training, and as I said, I also do training with all the student athletes in the fraternities and sororities, and we do in-person trainings for employees if they want that option as well. Any other questions? Thank you. Gotta go down this way.
Thank you so much, Annie. I tell you what, Shepherd's in good hands with Annie as the Title IX coordinator and director of social equity and inclusion. So what a great presentation. One thing, Annie, before you go, just want to mention one thing that you put up a slide on the technological abuse. We take those cases. We're interested in if you've got someone who's being harassed, someone who there's images that are being shared in order to extort someone, the sextortion as they call it, or any other type of abuse online. We're interested in trying to help with those cases. So.
Law enforcement struggles a little bit with that.
They're tough cases, and we've got some people in this room, including Sarah Wagner, who works on those cases on a regular basis. They're not easy, but the FBI's committed to it. We're committed to it, and it's really easy for people to hide behind different profiles online and to harass and hope not to get caught. But we understand that, and we're still interested in talking to you to see if we can help with those cases. And then interstate domestic violence and interstate violation of protective orders, right where we sit here right now, it's just, if that happens, then we have a federal statute for that as well, if someone crosses state lines with that intent. So keep us in mind. Okay, thank you. All right, very good. Our next presenters are Morgan McKee and Aaron Reisenweber. Morgan is a civil assistant United States attorney. She joined our office in January of 2021. Prior to that, she worked for 6 years in private practice, focusing on civil litigation defense. She serves as our district's financial litigation coordinator, and she also recently became the asset forfeiture coordinator in the office. Aaron supervises the Martinsburg location of our office, a very busy part of the U.S. Attorney's Office, and she's been with us for 15 years. Her practice focuses on civil defense work, including medical negligence and employment discrimination defense. Today, Aaron and Morgan are going to discuss Title VII of the Civil Rights Act of 1964 and how the Department of Justice works to prevent discrimination pursuant to this act. Aaron, Morgan.
Thank you. Stand here. Mhm. I think she's going to come up after I finish. We're going to split the presentation. Mhm. Can I just use that? Good morning. I guess can you hear me? We're moving closer to afternoon. Thank you, Bill, for the introduction. My name is Aaron Reisenweber, and I am a civil assistant United States attorney here in the Martinsburg office. I and Morgan are going to be talking about Title VII of the Civil Rights Act of 1974 and how it is enforced, and also how individuals can bring a claim pursuant to Title VII. As Chris talked to and as Annie discussed, individuals have the right to be free from discrimination in the realms of housing and in the education world. They also have the right to be free from discrimination at their workplace. I'm not moving. Thank you. Thanks, Stacy. This is just an outline of what I'll be talking about today. First of all, we'll talk to you a little bit about what Title VII is. I'll talk to you about what conduct is covered by Title VII of the Civil Rights Act, what employers and what employees are covered by the Act, what are some of the typical claims that an individual can bring in regards to discrimination in the workplace, and what are some of the defenses that we usually see raised by employers. Morgan will talk to you too about the exhaustion of administrative remedies, which is a step that individuals must take prior to bringing a claim under Title VII, and also what the Department of Justice does in enforcing Title VII. So Title VII of the Civil Rights Act of 1964, as amended, prohibits employment practices that discriminate on several grounds. Those grounds include race, sex, which also encompasses pregnancy, sexual orientation, and gender identity, as well as the grounds of religion and national origin. The Act also makes it unlawful to retaliate against a person. And you heard retaliation is a strong tool that Title VII holds. As Chris and Annie both said, oftentimes individuals are experiencing discrimination and they're afraid to come forward. The statute makes it an individual offense for an employer to retaliate against their employee for bringing a claim of discrimination. I'm now going to talk about each of those specific grounds. Race and national origin discrimination. This is when an individual in the workplace is discriminated against because of their race or color. This includes unfavorable treatment based upon that individual's personal characteristics that might be associated with a particular race, or based upon their skin color or complexion. National origin means that the unfavorable treatment that the individual suffers is because of the country or part of the world that the person is from, their ethnicity or their birthplace, ancestry, culture, accent, or other characteristics. Or it can be that a person appears to be of a certain ethnic background, even if they're not a member of that group. Race and national origin discrimination can also be based upon a person's marriage or association with a person of a certain race, color, or national origin. So if a Caucasian employee is married to an African American spouse, that Caucasian employee can suffer discrimination simply because of their marriage to a person of another race. And it also, marriage or association with covers attendance or participation in schools or places of worship, generally associated with a certain minority group, or even other cultural practices or characteristics linked to a specific race or ethnicity. Individuals can also be discriminated within the workplace based on sex. And sex discrimination under the statute now includes unfavorable treatment because of pregnancy, sexual orientation or perceived sexual orientation, gender stereotypes or failure to conform to gender stereotypes, and also gender identity or perceived gender identity. Title VII also prohibits religious discrimination in the workplace. This is the discrimination on the basis of religion in which a person might be denied equal employment opportunity because of that person's sincerely held religious, ethical, or moral beliefs. And that phrase, sincerely held, is an important part of the law because Title VII covers not only the traditional organized religions that most of us might be familiar with, but also religious beliefs that are new, uncommon, perhaps aren't part of a formal church, and might only be practiced by a small group of people. However, as long as the individual holds those beliefs sincerely, that is covered. That religion is covered by Title VII. And finally, Title VII's protections also extend to those who are discriminated against or need accommodation because they profess no religious belief at all. So hand in hand with religious discrimination is a phrase, reasonable accommodations. And an employer must make reasonable accommodation for religious beliefs, observances, or practices unless doing so would cause undue hardship on that employer. Examples of reasonable accommodation would be to allow the employee flexible scheduling because of a holy day. It also requires the employer to provide the employee accommodations for religious dress or grooming. Examples of this would be to allow an individual who practices Judaism to wear his yarmulke, or to allow a Sikh to wear his ungroomed long beard or hair. And when they talk about undue hardship in the statute, some examples of undue hardship to the employer would be if to allow this reasonable accommodation would provide a compromise, for example, to workplace safety, or if it would infringe on other individuals' rights. And it is the burden of the employer to show that to provide this reasonable accommodation to the employee would in fact be an undue hardship. Discrimination in the workplace can take many forms. It can take the form of refusing to hire a person. It can take the form of terminating or firing an individual, failing to promote someone, harassing or discriminating against a person with respect to any other term, condition, or privilege of the employment. Title VII prohibits not only intentional discrimination, but also practices that have the effect of discriminating against an individual. So although an employer may not take an action with the intent to discriminate, if the act has the effect of discrimination, then that is prohibited by Title VII as well. So let's talk a little bit about what employers are in fact covered by Title VII, and that's really most of them. Any employer with 15 or more employees, whether public or private, is affected by Title VII of the Civil Rights Act. Employment agencies are also covered by Title VII, as are unions. Who is covered? What employees can bring a Title VII claim if they're discriminated against in the workplace? Obviously, the employees of that employer, as well as anyone who applied for employment and might have been denied a position, as well as former employees. Independent contractors with an employer are not covered by Title VII. So what type of claims might we see in a Title VII case? First of all, you'll see those discrimination claims based on one of those protected categories that I mentioned earlier. Those are those cases where an adverse action is taken against an employee based on his or her sex, race, color, national origin, or religion. There are also hostile work environment claims based on a protected category. And I'll talk a little bit about those a little bit more in just a moment. And then again, like I mentioned earlier, retaliation. And this too is important because oftentimes in the Title VII arena, you'll have someone who is experiencing discrimination in the workplace and is afraid to bring that claim because he or she is concerned about what might happen. And so they can bring their claim, and if in fact they are retaliated for such a claim, that is a claim in and of itself. And then constructive discharge. Sometimes the hostile work environment that an individual might be experiencing becomes such that he or she decides to simply resign. And in essence, they quit because no reasonable person would stay in such an environment. And that is considered a constructive discharge and is covered by Title VII. So I mentioned a hostile work environment. A hostile work environment is often based on a series of actions occurring over a period of time that would not support claims in and of themselves. And as Annie mentioned in her presentation, the standard here is severe or pervasive. We don't require the and. These acts need not be severe and pervasive under Title VII, but severe or pervasive to the point that an employee feels scared, uncomfortable, or intimidated because of the unwelcome conduct. I will say, and Chris mentioned this in regards to the Fair Housing Act, there are times when an individual action can, in and of itself, be found to be a hostile work environment, but that is rare. Typically, there will be a series of conduct to which the employee is exposed to create a hostile work environment. So when an employee does bring a Title VII claim, what are some of the typical defenses that we will see an employer raise? And the first argument is the employer may claim that the employee cannot bring what we call a prima facie case. Prima facie being a Latin term which roughly means at first glance. And so there is a burden shifting scheme in Title VII claims. And when an individual first brings that claim, he or she must show that A, they are a member of that protected class. And two, that they were qualified for the job or that they were doing their job well, that they did not get the job, or conversely that they were terminated from the job, and that job was filled with a person not a member of the protected class. Another common defense raised by employers is that the employer had a legitimate, non-discriminatory reason for its action. So in other words, if an individual brings a claim under Title VII and argues gender discrimination, the employer's response may be, no, there was a legitimate reason for this individual being discharged, and we have a record of poor performance that we've documented through the years. That's often a defense that is raised. And then finally, another defense raised by employers under the Title VII, in a Title VII case, is that the plaintiff, the individual, failed to exhaust their administrative remedies. And as I mentioned earlier, prior to bringing a Title VII claim in federal court, you must first take certain administrative steps that, if not taken, may bar the person from making their claim in federal court. And I'm going to hand over the presentation at this point to Morgan, who is going to pick it up from here.
Thank you, Erin. So Erin just talked about kind of the basis for bringing a Title VII action and kind of what types of discrimination can occur that would cause you to want to bring one of those types of claims or make some type of complaint. I'm going to talk about the process now that you would need to follow before you could bring one of those complaints in federal court. So exhaustion of administrative remedies in an employment discrimination type case means that you have to first present your grievances to the agency within the timeliness established by regulation. The entire process is very closely tied with different deadlines and different time frames that you have to do certain things. Exhaustion is required because it gives the agency the opportunity to resolve the grievance if they can before they become the subject of a lawsuit. And there's different ways that we can attempt to resolve it before coming to court. If you fail to exhaust your administrative remedies, that will normally preclude judicial consideration of a Title VII claim. If you were to just bring the lawsuit in federal court, a motion to dismiss would likely be filed soon thereafter stating this, and the case would be dismissed pretty quickly if you did not follow the correct process ahead of time. It's important to remember that exhaustion is the thing that the complainant must do, and the statute of limitations are when they must do them. And the statute of limitations, again, are like those time frames and those dates that you have to do certain things. For federal employees, the rules are somewhat different, and they are found in 29 CFR 1614 Part 100. I'm not really going to go into those, but it is different, so that's important to know. There's actually a little stricter time frames and different things that you have to do. So a charge of discrimination is a signed statement asserting that an employer, union, or labor organization engaged in some type of employment discrimination. This charge is required before an employee can file an employment discrimination lawsuit against their employer. And a charge is another word for a complaint that you're going to make. The charge must be filed with the EEOC, which is the Equal Employment Opportunity Commission, or a state enforcement agency, regardless of who the employer is. One note is that if you file with a state agency, that automatically also files with the EEOC, so you're kind of taking care of both. You don't need an attorney to file a complaint with the EEOC, and it doesn't cost any money to file a complaint. And in fact, if anyone ever wants to file one of these, the best thing to do is go to their website, and it will really walk you through every step that you need to take and direct you in the right direction and give you who you can contact, and it's very helpful on the website. After that, if the EEOC completes an investigation, which is what they will do, and determines that your charge actually has something to it, and then their efforts to obtain voluntary compliance are unsuccessful, the EEOC will then refer the charge to the Department of Justice Employment Litigation Section. So a charge of discrimination should be filed, again, this goes back to the important time frames, needs to be filed with the EEOC within 180 days from the date of the alleged violation in order to protect the charging party's rights. The 180-day filing deadline can actually be extended out to 300 days if the charge is also covered by any type of state or local anti-discrimination law. I forgot to mention, I'm sorry, that sometimes before the EEOC does their investigation, they can offer mediation for you and your employer. This is just one of the tactics that they take to try to settle things outside of court. And sometimes it's successful, sometimes it's not, but they may offer you that. And the investigation that the EEOC undertakes, it involves interviews, document gathering, talking to different witnesses. Sometimes they just do it via phone calls. Sometimes they would actually go to the place of employment. And there's no time limit to complete the investigation. So they kind of have an unlimited amount of time to do it. So an important distinction to make is a discrete act versus a hostile work environment claim. And Aaron talked a little bit about the hostile work environment claims that can be brought. This is an important distinction. A discrete claim of discrimination, each of those claims has to be administratively exhausted. An example of a discrete act is kind of like a one-off type thing, like a failure to hire or a termination type case where it's just like one thing that happened. That's a discrete claim. And if you have multiple of those one-time instances, then those have to be administratively exhausted. A hostile work environment claim, that would be kind of like an ongoing type situation, multiple different acts over a certain period of time. And there's a certain time period for which, do any of the alleged acts fall within the limitations period? And so basically if one of the, I think like the last act, the last discriminating act, you have then a certain time period to file after that. Let's see. So in the federal sector, I said I was going to talk a little bit about this, I guess. It's a little bit different of a process. You would need to consult with the EEO counselor to attempt an informal resolution of the complaint. And the EEO counselor would be someone at the actual federal agency. So that's who you would go to first. Then after that, you would file a formal administrative complaint if you couldn't resolve the issues. The agency does an investigation of your complaint. You can request an administrative hearing, or you can just request an immediate final agency decision. And then after that, you would be able to appeal to the EEOC. So the certain substantive requirements for an exhaustion of an administrative remedy is that your complaint must be encompassed by the administrative charge. And I think Chris showed the form that had like a bunch of little boxes down below. There's really important to pay attention if you're doing a charge to see what boxes that you check, because that's something that is then looked at later on if you are to bring a claim, to make sure that you are alleging the same things that you did before, essentially. Good faith cooperation during the administrative process is required. You can't be, refusing to talk to anyone, or refusing to try to mediate or to work things out, to try to push it quickly to be able to get to federal court. You need to show good faith effort to resolve things. Again, discrete acts have to be separately exhausted. And the continuing violation doctrine is what retains vitality for hostile work environment claims in pattern and practice cases. And the continuing violation doctrine is if an employee files an EEOC charge while at least one act constituting the hostile work environment is still timely, so that one act still falls within that period of time, then the whole period of the hostile work environment can be considered for purposes of deciding liability. So that's what makes it a little different than the discrete acts. The time limits for filing civil Title VII actions. Title VII claims arising from individual EEO complaint process, they must file within 90 days after the final administrative decision. The plaintiff must wait at least 180 days for a final administrative decision. And it's important to note that the filing deadline is not jurisdictional. So the venue for filing Title VII claims would be in any judicial district in the state where the unlawful act is alleged to have been committed, the judicial district where the employment records relating to the prescribed conduct are kept. That's one you probably wouldn't think of. The judicial district where the plaintiff would have worked but for the alleged unlawful act, and that would possibly be in like a failure to hire case. If you applied somewhere and you said you were discriminated against and didn't get the job, then you moved to another state, you could still bring that case in the state where you would have worked had you been hired. Or where the defendant employer has its principal office, but that's only if there's no other appropriate or more appropriate venue to bring it. So there's lots of different options. So the next thing I'm just going to talk about is, I talked about how the EEOC handles the employment discrimination claims and how you have to kind of start there. But there's also, as Chris talked about in his presentation, an interplay between the Department of Justice and how we get forwarded types of claims by the EEOC to go ahead and handle. So the DOJ has a Civil Rights Division Employment Litigation section, people specifically assigned to do this type of thing. It enforces against state and local government employees the provisions of Title VII of the Civil Rights Act of 1964. The section also enforces against state and local government employees and private employers of the Uniformed Services Employment and Reemployment Rights Act of 1994, so that's for veterans. There's a certain act that applies to them. And the EEOC enforces Title VII against non-government employers, as well as the Americans with Disabilities Act and the Genetic Information Non-Discrimination Act. So complaints under Title VII are filed with the EEOC, as we said. This is kind of the process for how it works. Then the EEOC accepts and investigates the complaints based on all of the different areas that Aaron had talked about before. There's lots of different causes of action. Then the employment litigation section of the DOJ has authority to file suit against a state or local government employer based upon an individual charge of discrimination referred to them by the EEOC. And that's only following a determination that the charge has merit, and efforts to obtain voluntary compliance are actually unsuccessful. So it's kind of like a last-ditch effort here. Pattern or practice, the DOJ has authority to initiate investigations and prosecute enforcement actions against employers where it has reason to believe that there's a pattern or practice of employment discrimination occurring. Only the EEOC can bring a pattern and practice enforcement action against an employer. Private plaintiffs who assert one of these types of actions have to satisfy requirements of the class action rule. So it's a little bit different for a private individual to bring one of these types of claims. Again, generally these pattern and practice type of claims, usually a class action by a private individual, is in which the plaintiff alleges systemic discrimination against a particular group not just a specific individual. And the claim is that the discrimination is the employer's standard operating procedure. So it's going to be a little more difficult to prove, and you're going to need a lot of support for your claims, but you can certainly bring one of those. Statistical evidence combined with anecdotal evidence from persons who claim to be victims of the alleged discriminatory pattern and practice are required, or definitely needed, if not required, for your claim to survive. And to file a complaint, if the employer is a state or local government employer and the discrimination is based on a discriminatory policy or practice, you can file a complaint actually through the DOJ portal, and the website is there. Individual complaints have to first be filed with the EEOC or the State Human Rights Commission. If you file with the EEOC, an investigator will contact the person by telephone and conduct an interview to kind of start the process. I have one interesting example of a recent case where the Justice Department filed a religious discrimination suit against the city of Lansing, Michigan. This was just this year. They announced that they were filing a lawsuit against the city of Lansing, alleging that it discriminated against a former detention officer on the basis of her religion, where it terminated her based upon the fact that she said she couldn't work in religious observance of the Sabbath. And so it was actually referred from the EEOC to the Department of Justice, who ended up having to take the case and are now pursuing that against the city. So that's just one example of a recent situation where the EEOC got the DOJ involved, and they worked together to try to take care of this discrimination that was going on. And that's all that I have. Does anyone have any questions for Aaron or myself? Okay, thank you.
Thank you, Morgan. Thank you, Aaron. Our final segment will be presented by Sarah Wagner and Jared Douglas, who both serve as criminal assistant U.S. attorneys in the office, and they both have a great deal of experience handling complex, sophisticated, and very sensitive matters. Sarah regularly handles criminal civil rights cases and has developed a great deal of expertise in that space. Prior to becoming a federal prosecutor, she worked in the private sector for a prominent plaintiffs firm and also clerked for the U.S. Court of Appeals for the Fourth Circuit. Jared also handles criminal civil rights matters and has done so with a great deal of success. He is also the primary point of contact on national security cases in our office and leads our anti-terrorism efforts. He was a law clerk for Judge John Preston Bailey, federal judge here in the Northern District of West Virginia. Today, Sarah and Jared will be talking about the DOJ's United Against Hate initiative, and they will focus on identifying, reporting, and preventing hate crimes and explaining what federal and state hate crime laws are available to law enforcement and prosecutors. They will also cover some statewide and nationwide statistics about hate crimes, some of the problems in underreporting hate crimes, and ultimately how to report hate crimes and what resources are available to community members in order to report hate crimes. So, Sarah and Jared, please take it away.
I'm going to stand up here. Good morning. Again, I'm Sarah Wagner. This is Jared Douglas. We're Assistant United States Attorneys. Jared is out of the Wheeling office. I'm out of the Clarksburg office. And as Bill said, we are here to do a presentation on hate crimes. We are very happy you're here. We thank you for sticking with us as we get closer to the lunch hour. We'll try not to keep you longer than need be. But hate crimes create fear and divide communities. And today is an opportunity for all of us to learn more about hate crimes, as well as how we identify them, how we report them, and how we prevent them. And so we want to spend time learning about what resources are available to you all as members of your community, and also to talk about what role you might play in uniting communities should such an incident occur here. We've all seen too often how individuals who are filled with hate commit these atrocious crimes, horrific violence just unleashed on marginalized communities. Recently, the Tops Market massacre in Buffalo, New York, that claimed 10 lives. In the past few years, we've seen hate-fueled massacres at the Walmart in El Paso, Texas, the Tree of Life Synagogue in Pittsburgh, Pennsylvania, which for many of us in the Northern District of West Virginia, that's pretty darn close to home. The Mother Emanuel AME Church in Charleston, South Carolina, and the Sikh Temple in Oak Creek, Wisconsin, as well as the attack on civilians at the Unite the Right rally in Charlottesville, Virginia. So all of these tragedies leave a terrible mark on the communities, but these are just a few of the many more incidents that don't garner media attention. Let's see if I can do this right. Okay, so what we're going to do today is we're going to first provide an overview of what hate crimes are, and help you identify them if you happen to be witness to them. We'll talk about how to report them, both hate crimes and incidents which might not rise to the level of a crime, but something we would call a hate incident that is important for law enforcement to know about. And then we will discuss strategies for preventing hate crimes, which largely focuses on strengthening relationships between community groups and law enforcement. And we'll have a few short video clips during this presentation, so you won't just have to listen to Jared and I talk, but the most important thing about today's presentation is what happens when you leave here. We want you to feel encouraged to report hate crimes or hate incidents that you see. We want you to feel inspired to get involved in your communities in ways that can, in connection with their prevention efforts. And also, we hope that you will give us feedback about what our office, the United States Attorney's Office in this district, can do to help facilitate reporting, help facilitate training, whatever it is we can do to help in this process. Okay, so I'm going to turn it over to Jared.
So perhaps to get into the right mindset, an appropriate mindset when we're talking about hate crimes, we're going to show you this video called Waking in Oak Creek. It's about a community's effort to heal following a deadly hate crime that killed 6 worshipers in a Sikh temple in Oak Creek, Wisconsin, back in 2012. And actually, this film was produced in conjunction with the U.S. Department of Justice COPS office as part of its Not in Our Town Working Together for Safe, Inclusive Communities initiative. So we can play it, I think it's about 3 minutes long. If it doesn't work there, I think there's a link in the notes section too.
That's what we're trying to click on, but it's not cooperating.
Oh, there we go. No, okay. Thank you.
Let's see if it's better. Hold on. Woo. Hold on. We all should have a lightsaber. Sorry. Let's go back to this. Nope. your PowerPoint. Sorry. Nothing works the way I want it to today. Why can't they see it?
If not, we can listen to it.
I don't know why it's not showing it up. There we go. Sorry.
So the video shows, of course, the devastating impact that hate crimes can have on communities, but it also shows the potential for communities to begin the healing process together by coming together and supporting one another. So why hate crimes? Because we have general criminal laws that, of course, prohibit murder, assault, threats, or other conduct, but why also should we bring a hate crime specifically? Well, they matter, number one, because of the impact that we just saw, and as this slide sort of illustrates, because that impact goes beyond just the victim of the crime, that person's family. It also traumatizes others who share the trait or traits of the victim. It traumatizes the victim's community, and sometimes even the entire nation. Hate crime prosecutions also matter because people who commit those crimes, they often intend to frighten all members of that particular community, not just the one that actually becomes the victim of the crime. Hate crime prosecutions matter because following those hate crimes, victims, members of that group, and their greater community may feel afraid when carrying out just normal daily activities. They no longer have the sense of safety in just their simple daily lives. These types of prosecutions also matter because attacks that are motivated by bias, they tend to be more violent than other attacks. Plus, perpetrators of hate crimes are more likely to commit them again. Finally, prioritizing hate crimes gets dangerous offenders off the street. It also sends a message to members of the targeted group that they are valued members of society and that their protection matters. So let's start by talking about hate crime and hate crime incidents and understanding why hate crimes are treated differently than other crimes. What is a hate crime? This is a very simplistic illustration. Of course, you're going to have a crime that is motivated by quote-unquote hate. In general, a hate crime is a criminal offense such as murder, assault, arson, vandalism, or threats that is motivated by one's hate against a group or a class of people that's protected by law. Now, the term hate is a bit misleading. While individuals who commit the hate crimes often, in fact, do hate everyone who has that characteristic that the targeted victim has, but the law only requires that the crime be committed because of those characteristics. So there's usually no requirement that we will need to prove that the defendant universally hated everyone within that particular group. These are the classes of people who are protected under some, but not all, federal hate crime statutes. We'll discuss a little bit later. There are also federal and state laws that protect these classes from some conduct that really is not a crime, but there's still a protection there. We're going to dive in next to just look at some of the federal hate crime statutes that are available. We have the Hate Crime Prevention Act. There are certain provisions of the Fair Housing Act that Chris was presenting on earlier. Section 245 addresses certain federally protected activities. And then we're going to have those that relate to religious property and, of course, the exercise of religion. Now, there is a certain commonality among all of those four federal hate crime statutes, and that is that we're going to need to prove that the defendant committed the certain act that's prohibited because of the characteristic at issue, because of that classification. In other words, we like to look at it as, but for that characteristic, this crime would not have taken place. There are certain differences as well among the federal hate crime statutes. Number one, with regard to the kinds of violent conduct they're going to prohibit, with regard to the biased motivations that are going to be reached by those statutes, and what makes it a federal offense is going to differ among those statutes. We'll start with the Hate Crime Prevention Act. We'll probably stay here for, I think, 3 slides. It's, as it states here, the most commonly charged federal hate crime. That's probably because it covers the most categories of bias among those that are available to us. It is not without its limitations. It does not apply to threats. So we're only going to be dealing with matters of actual violence that was used. You can kind of conceptualize it, and it's organized in 3 different categories: racial hate crimes, the non-racial hate crimes, and then hate crimes that occur on federal land. Now, all of them are going to require proof that the defendant willfully caused bodily injury to another person or attempted to cause bodily injury by one of the enumerated uses of a dangerous weapon, or sort of the catch-all general phrase, or other dangerous weapon. Bodily injury is defined pretty broadly in the statute. It's defined to include minor injuries such as scrapes, bruises, and even physical pain. But it does not include solely emotional or psychological injury. So it needs to still be a physical injury of some type that's to be covered by this statute. Regarding the attempt, or is a very important word in the legal profession, because either this or we only have an attempt here, but it has to be an attempt with a weapon. So, for example, if a defendant swings at a victim with his bare fists and misses, then the law is not implicated, even if the defendant is clearly motivated by a bias that is covered in the statute. But if the defendant takes the same action but with a knife in his hand, that act would constitute an attempt and would be prosecutable under this statute because now we've involved a dangerous weapon. As it states here, all three of these categories within the Hate Crime Prevention Act criminalize assaults undertaken because both of actual and perceived characteristics. So if a defendant assaults a heterosexual person believing that the victim is gay and that's why they're assaulting them, then the statute will be fully applicable. Finally, there's some significance to the use of the phrase any person, the characteristic of any person being the motivation for the crime. And that's because, for example, if a defendant assaults a white man because he's dating a woman of color, then the assault is prosecutable under this law, even though the defendant was not motivated by the victim's race, but rather by the race of the woman the victim was dating. So there's sort of a transference of that intent. So here on this slide, we're kind of laying out those three categories within the Hate Crime Prevention Act. When you look at the first, racial hate crimes, there is no requirement to show any effect on interstate commerce. So it is simply already a federal offense, and that's just because of the origin of the authority that Congress had to pass that particular provision, being that it was based in race, so it had to do with abolishment of slavery in the 13th Amendment. So that makes it a federal offense. There's no additional requirement to bring it into federal court if that's what you're dealing with, if that's what the motivation was. Here, however, when you take that out of the equation, now you are going to have this additional element to bring under this provision of the interstate or foreign commerce effect. In that regard, the statute does provide a lot of examples of what could be used to satisfy that element regarding the effect on interstate commerce. For example, whether there was travel across a state line, or whether there was a use of some type of interstate instrumentality that was in connection with the offense, like a cell phone or something like that, or the internet. Also, whether if there was a dangerous weapon involved, whether that weapon happened to travel in interstate commerce, whether there was an interference with commercial or economic activity in which the victim was engaged at the time of the offense. And then there's sort of what we call a catch-all provision, or it otherwise affected interstate or foreign commerce. And then finally, what makes this last part a federal offense is simply that it was occurred on a federal property. The next statute we'll just look at very briefly is the criminal provisions that are found within the Fair Housing Act. This is really pretty useful when you're dealing with threats, but the threats still need to be delivered at or near the victim's home, or otherwise interfere with that victim's ability to enjoy the home. So you have use or threatened force, interfered with, because of these certain characteristics. And then the fourth that's peculiar to this act is that it must be because the victim is enjoying one of these rights. Most often used is just the occupation of a dwelling. The most prototypical example are those cross-burning cases. Then we have Section 245, which goes toward certain federally protected activities. This is also going to be very useful in threat cases, and those threat cases that you can't really connect to a housing right. Now, it has its limitations as it doesn't apply to these certain bolded biases that are listed here, but it's still good for threats where you can't have a connection to housing. There's a lot of federally protected activities that are included within this statute. Attending or enrolling in public school or college. So I think back a few years ago, there was a defacement of a statue on the campus of Mississippi State University, like a noose or something was hung on it. And that would be something that could be possibly applied here because it's sought to interfere with someone's federally protected right to attend or enroll in a public school or college. But the list kind of goes on, applying for or enjoying state or private employment, serving on a state jury or attending state court regarding such service, traveling or using a facility of interstate commerce. It goes on and on. The point is just that, look, there are a lot of federally protected activities. We're the ones kind of charged with knowing those, and we will do so if you report these to us. The final federal statute that we'll look at is Section 247, which goes to the damage of religious property and exercise of religious beliefs. It's called the Church Arson Prevention Act, but it's broader than that. It goes much to more than just arson. It's going to apply to intentional damage to religious property and the forceful interference with an ability to worship. It's also divided into sort of three subsections. Destruction of religious property because of religion is one, because of race is a separate one, and then the interference with practice of religion. Looking first at the damage to religious property because of religion, a category, the first element we're going to have to prove there is that there was a defacement or damage or destruction of religious real property. The statute does have a definition of religious real property, and it includes any church, synagogue, mosque, religious cemetery, or other religious property, including fixtures or religious objects contained within a place of worship. The law is developing in this area. In 2018, the term religious real property was broadened to include real property owned or leased by a nonprofit, religiously affiliated organization. So it would not even have to really be in and of itself a church or one of these typical real properties, but could be a nonprofit that's just affiliated. Now there is going to, I was just going to note, but it does require the interstate commerce because again, now we're in sort of the religious area. Outside of the race area, you're going to have some additional element to show that it's a federal offense. Interference with the free exercise of religious beliefs. That's going to be by force or threat of force. Again, you're going to have to show a connection with commerce, but it does not require proof that the defendant acted because of any person's religion. So that's pretty unique in this landscape of hate crime statutes. Probably the most well-known, or at least recently, case that involved this was the Dylan Roof case, the shooting at that church in Charleston, South Carolina that Sarah referenced in our opening. That happened back in June of 2015. In that case, there was some litigation with regard to the interstate connection with interstate commerce. The district court at the trial level had upheld the constitutionality of that section as a valid exercise of Congress's power to enact legislation pursuant to the Commerce Clause. And then the Fourth Circuit in Richmond, which is our appellate court for the Northern District of West Virginia and elsewhere in this region, affirmed that decision, upheld that decision. But it did stress that Roof's use of the internet to plan and execute an attack on a church satisfied the Commerce Clause jurisdictional element, primarily because it was, quote, closely linked both in purpose and temporal proximity to his violation of the religious obstruction statute, end quote. So this evidence, along with Roof's use of a phone, GPS, interstate highway, when taken together, was in that case sufficient to meet the Commerce Clause element. The court did caution, though, that, quote, alone, each of those activities might be insufficient to satisfy the Commerce Clause. So it's going to be very factual dependent. Finally, is the last section within 247, which goes to destruction of religious property because of race. Again, as we've said over and over, there is no, because it's based on race, there's going to be no commerce requirement.
All right, so now Jared's covered the federal statutes. What I want to talk about is just the fact that in addition to the federal statutes that we just looked at, there are, most states and territories have their own hate crime statutes that are enforced by state and local authorities and courts and law enforcement agents. So hate crime statutes in different states and territories, they vary in terms of who is protected. So we just looked at who's protected federally. In some states, in addition to covering those classes of individuals, they may also include age, political affiliation, homelessness as additional protected classes. State laws vary about whether and how criminal penalties are addressed, whether laws allow for individuals to sue civilly, whether the range of crimes that are covered, whether they contain, the laws contain reporting requirements, and whether the laws require training of law enforcement personnel. So you don't need to know all of the nuances of state law or federal law. As Jared said, it's the lawyer's jobs to figure that all out. But the takeaway is that it's hard to tell whether a given set of facts will result in a prosecution, whether federal or state. But it's critically important for community members to report all hate incidents, because it may be something that would be evidence in a later hate crime. We'll talk a little bit more about that, but it's important, regardless of whether you as a community member can say that rises to the level of a crime or it does not, to go ahead and report those incidents to law enforcement. Okay, in West Virginia, the protected classes are race, color, national origin, religion, sex, ancestry, and political affiliation. And so you see there's some overlap with the federal protected classes. We have ancestry and political affiliation that's not covered federally. But what West Virginia is missing are those ones to the end there: disability, sexual orientation, familial status, and gender identity. And there have been some Supreme Court cases that would probably give someone under state law the support to argue that sex, which is a covered class under West Virginia law, might extend to sexual orientation and potentially gender identity. But those are not as clearly set out under state law. So another way that the West Virginia law is different than federal laws, we've just got one hate crime statute, but it does do three different things. It sets out two separate felony provisions as opposed to misdemeanors. If someone is convicted of one of these crimes, they could go to jail for more than a year. One crime is a bias-motivated violence or intimidation. The second crime is conspiracy to commit a bias-motivated crime, violence or intimidation. But the statute also sets forth that even if a person isn't convicted of a hate crime, of this hate crime, the sentencing judge may consider bias motivation at sentencing. So if the state prosecutor is only able to prove arson, if they have evidence that the arson was motivated by race, then they can make that known to the sentencing judge, and the sentencing judge has to consider it. So when we talk about elements, we're just talking about what the prosecutors have to prove at a trial. And in the case of a bias-motivated violence and intimidation crime, it's a use of force or threat, a willful attempt to injure, intimidate, interfere with, oppress, or threaten another person in the free exercise or enjoyment of a secured right, and motivation based on one of those protected classes. Now, force or threat of force is not defined under the state law as it pertains to this particular statute. Sometimes the state courts will look to federal courts for how those terms have been defined. And federal courts have found the term force to include actions such as physical beatings, bombings, shooting of a weapon into a residence. And they have found that threat of force includes things like waving baseball bats, axe handles, or knives, throwing rocks and bottles, veering a car towards a person, or physically chasing a person. And it can also include symbolic conduct where the threatening message is clear. So cross burnings, in one instance it was a letter to the director of an interracial adoption agency who threatened to basically threaten death to minorities and to anyone who would associate with them. The West Virginia hate crime statute does not include mere vandalism because mere vandalism lacks that use of that threat of force. The secured right provision in the second element, it basically is codified within the law. So basically the law says that all persons within the boundaries of the state have the right to be free from any violence or intimidation by threat of violence committed against them because of one of these protected characteristics. So that's not hard to prove because the statute confers that right on victims, on everybody. The term willful, basically it's not negligence, it's not by accident, but this is often not something that's difficult to prove because if evidence establishes that the act was motivated by race, it's not going to be hard to show, or motivated by a bias, it's not going to be hard to show that it was also willful. And West Virginia case law interprets, in the context of a similar provision, what the phrase motivating factor means. It doesn't, or what motivation means. It doesn't have to be the sole or even the primary motivating factor. It simply has to be a motivating factor. And the penalty for a violation of this statute is up to 10 years in prison. The conspiracy component of the West Virginia hate crime law, basically we would have to show that the person conspired with another to willfully injure, intimidate, interfere, oppress another person in the free exercise or enjoyment of a secured right, in willful furtherance thereof to assemble for the purpose of teaching and any technique or means capable of doing so. So they got together for that purpose, and again, motivated by these protected classes. And in a conspiracy, the state prosecutor would not have to show that a specific act or threat of force actually occurred. So if the perpetrators conspired to injure or oppress, threaten, intimidate, and met together to teach such techniques, then that suffices. And this also carries a 10-year statutory maximum. And then again, the sentencing enhancement, this just sets out that a person who commits either a felony or misdemeanor or attempts to do so under any other provision of West Virginia law because of one of those protected characteristics. In those instances, the sentencing court shall consider it a circumstance in aggravation of a crime and imposing sentence. Basically, the sentencing court has to look at that as an aggravating factor, a reason to potentially increase the sentence. It doesn't mean the judge has to, but it certainly gives the judge a basis to impose a stiffer sentence. So again, this would apply even if there's, it's a generic assault or vandalism or some other crime that has the bias motivation. So just shifting gears a little bit, a lot of times we might hear in the news, someone's planning a KKK rally and everyone is up in arms. They don't want you coming and talking about, expressing these ideas. And we might wonder, why aren't these people being arrested? Why are they being allowed to do this? Well, hate speech is not illegal, so long as it doesn't advocate or threaten violence. But under the First Amendment, we have the right to express ourselves. We have the right to express even very hateful messages. This is the same protection that gives us the right to have a free press, to go to church, wherever we wish or not at all. So the limits on free speech, which do exist, basically are that when speech advocates or threatens violence or encourages people to commit crimes, that's when it becomes illegal. And so depending on the circumstances, you might have an instance where hate speech is a hate crime, but it must contain a true threat, meaning that the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to particular individuals. And again, whether that's not something for you to be able to figure out as members of the community, we would ask that these types of this type of hate speech also gets reported, because if it does not rise to the level of a threat, it still tells law enforcement something about what's going on. It could be evidence connected to another crime. If somebody commits a hate act 3 weeks later and they're out here spewing this speech, hate speech earlier, that's evidence that what they did 3 weeks later was for the purpose or was motivated by their bias. So let's just talk about a couple of statements, just so you can kind of get a sense of what constitutes hate speech and what, or when hate speech constitutes illegal conduct. Let's say you're walking through a public park and you hear these 3 statements. We're going to talk about them individually. Our race is superior to other races. That's the first statement. The second statement, we need to take a stand for our race and destroy those who stand in our way. And the third statement, those opposing our race, like those people over there, are the enemy and must be attacked now. So that first statement, our race is superior to other races, it's hateful and offensive, but it's protected speech. The second statement, we need to take a stand for our race and destroy those who stand in our way. The law allows for exaggeration and strong speech. The word destroy in that statement could suggest that violence would be used, but it could also refer to political or social action. And so without knowing more about the speaker's plan or the group's plan, then the speech would be protected. The third statement, those opposing our race, like those people over there, are the enemy and must be attacked now. This is getting much closer to the line, because you're talking about individual people, particular people, and imminent action. And so you would want to know more about, obviously, what the plans are, but that would be something much, much closer to a hate crime than the other 2 examples. And here we have an example. This is from a real case, United States versus Ledford. And this individual in Iowa who had a criminal history involving firearms sent 2 Facebook messages to a religious organization in Massachusetts. And if you read from the bottom up, the first message says, your prophet is a child rapist, a murderer, and a molester. You all will go to hell with your father Satan, and we will destroy you here and in your shithole countries. The second message includes a picture of someone with an assault rifle and says, this is for you followers of the piece of shit prophet. And so again, going back to what a true threat is, it's a communication of a serious intent to harm. And the defendant must also be shown to have intended the communication to be interpreted as a threat, or to know that it would be interpreted as a threat. And so to show the difference between hate speech and a true threat, if we look at the first sentence, your prophet is a child rapist and a murderer and a molester, that's hate speech. That sentence with the next sentence, you all will go to hell with your father Satan, is a little closer to a true threat because it mentions going to hell, which, you know, has a component of death sort of implicit in it. But probably by themselves, those 2 statements would not be a true threat. You add the third sentence to that, and the use of the word destroy gets much closer to being a true threat, but could arguably be more of a position of advocacy rather than a true promise to injure. The fourth sentence says, this is for your followers, with the picture of the assault rifle. So the 4 statements together, plus the picture, were used in this particular case to get a guilty plea. Those four statements and the picture together equated to a true threat. Okay, so just talking about hate incidents versus hate crimes and discrimination. Communities generally will trust law enforcement more when they see that the police are acting on their complaints. But as we've kind of talked about already, not every hate-motivated statement or conduct can be prosecuted as a hate crime. So law enforcement might analyze this evidence. They might do a fulsome investigation, but still not be able to prove all of those elements that we've been talking about this morning. But there are things that can be done. Some hate incidents like bullying and harassment in elementary and secondary schools, and certain mistreatment in housing and public accommodations, those might be considered discrimination under other federal laws, and the Department of Justice enforces those statutes. And so if you think that you have someone in your community, something you've witnessed, someone you know, or you yourself have been the victim of a civil rights violation of any of the sorts we've been talking about today, you can report them to the FBI on their tips line or to the Civil Rights Division of the Department of Justice. And we'll talk a little bit more about them. But again, even when a hate incident cannot be prosecuted, the information is still useful to law enforcement. And so we would ask that you report those, even though they may not rise to the level of a crime.
So we're going to speed it up here. I know we're pretty much out of time. And we're only to the second objective. So now you have a better understanding of how to identify the hate crimes. Let's talk about what you should do when one occurs. First, of course, you've got to immediately get help, call 911. That's not only going to have emergency help in that regard, but also it's going to allow you to report the crime to your local law enforcement, who's going to respond to that as well. Once everyone is safe, then we'd ask you to also make a report to the local FBI field office, which you can do through the FBI tips or by finding through the internet and the FBI's website the field office to report it to. Ours would be for Pittsburgh. And we'd ask you to encourage victims to report and seek support services such as counseling to help cope with the crime. Victims can also obtain additional support from the DOJ. We're going to skip this. So when you're reporting what you think is a hate crime, there's certain factors you need to think about reporting. Whether the victim is a member of a protected class of which the perpetrator is not a member, whether there were certain comments or written statements or gestures were made by the perpetrator, whether there were certain drawings or symbols of hate that were near the victim or the crime scene, whether the perpetrator is a member of an organized hate group, and whether there have been previous hate crimes or incidents of this same group near that same location, and whether the location is near a religious site or place of significance to a protected class. Every year, the FBI releases reports on data that they receive from law enforcement agencies across the country. This is one that was released last fall regarding hate crime incidents in 2020. This was reported or gathered from over 15,000 law enforcement agencies. 85% of those agencies reported no hate crimes had occurred. The remaining 15% reported about 8,000 hate crime events. This chart shows the demographic breakdown of who those single bias hate crimes targeted. There was an increase in reported hate crimes from 2019 to 2020 of almost 950 more single bias hate crimes reported in 2020. You look at this chart and you're thinking 8,000 hate crimes is probably low compared to obviously the population of the country, and that maybe some of these classes are lower than you expect. But with 85% of law enforcement agencies reporting that no hate crimes occurred, it's impossible really to draw conclusions or assess trends from this data, which is a prime example of why it is so important to report hate crimes to law enforcement, because that's the police departments are using those reports to report their statistics on to the FBI.
And in West Virginia, these are the number of hate crimes that have been reported. I think this is also from 2020. So basically about a total of 54 hate crimes throughout the state in one particular year. The breakdown is not too much different than the federal statistics as far as what category these are being reported. And then, there's similar trends over the last 3 years. Although 54 hate crimes in our state sounds like not a lot, and we might feel compelled to congratulate ourselves on not having a problem, we believe, as Jared said, that these are largely unreported crimes, and we believe this in part because of a survey that the United States Census has done recently that shows that basically there are 107,000 hate crimes reported to police, but during this this survey, more than double that amount was reported to the survey, to the census workers. And that's disturbing, but what is equally sad is that the reasons why victims have explained they don't report hate crimes. A lot of them say it was handled another way, privately or through a non-law enforcement official, but about a quarter say they didn't report to police because they did not believe that the police could help or would help. 16% believed that the case was not important enough, the crime was not important enough to report to the police, and another 14% had another reason for not reporting. And some feared reprisal by reporting. And so when we talk about at the beginning of this presentation about building those connections with between law enforcement and community organizations, if we do that, each of these reasons will tend to dissipate because people will trust each other to do the right thing and will understand how important it is to fully investigate. And so that is the reason that we want to really make those connections and strengthen those connections.
So when we're talking about the resources that are available to prevent hate crimes, of course, law enforcement plays a role, specifically local law enforcement. Those are going to be your first point of contact in any crime, including hate crimes. They're going to be the ones doing a lot of the groundwork at the beginning to determine whether they've found evidence initially that could lead toward a hate crime prosecution. On the local and the state side, the prosecuting attorney's office is going to decide whether the evidence gathered might meet and satisfy the elements of a state hate crime. Federally, we're going to have the FBI that we're dealing with and federal prosecutors like Sarah and me, as well as our coordination with the criminal section within the Civil Rights Division at the DOJ.
Okay, and these are just some resources. These are not DOJ websites, but these are websites that have sort of collected resources in different communities. They've got state-by-state connections, and then of course there's the West Virginia Victim Assistance Program, and if you want these links, we can get them to you after our presentation. This is just the DOJ components who address hate crimes. FBI is the lead investigator on these cases. The Civil Rights Division, Jared just explained, in the United States Attorney's Office, those are the lawyers who prosecute these cases. There's a community relations service, and what they essentially do is when there's an incident, a hate crime incident in a community, they serve as sort of a mediator, a third party that helps make connections and helps communities deal with sort of the aftermath of these things. There's also the Office of the Community-Oriented Policing Services, whose responsibility is to advance the practice of community policing by making these connections between law enforcement and community groups, and also providing training to local and state law enforcement agencies through grants and providing trainings themselves. And so you can find out more on the DOJ Hate Crimes website about what we are doing. You can find more statistics, and you can also learn about training that the DOJ will help facilitate. These are things that could be done in your community on a sort of a broader scale than what we're doing here today. But those are things that you can find on the website. And then there are specific resources for protecting places of worship, which includes trainings on how to protect your particular place of worship, how to increase security, and how to basically deal with the aftermath if one of these terrible things happens in your community. These were our goals today. We hope that we have helped you learn how to report and respond, become more aware, understand the importance of building relationships between the community and law enforcement, and just be able to communicate amongst those groups and, of course, with our office. We thank you for being here today. Does anyone have any questions for us?
Going back to the slide you had on community service office or something, is there such an office here in the family?
I don't know the answer to that, but I will find out for you.
Hadn't heard of it.
Yes, sir.
Back here. You know, I think for me, a very interesting aspect of all of this is the hate incident, which is not the hate crime, and the feeling that the community needs to be aware of a escalating hate incident that could escalate into a hate crime. And how do we report, or how do we make aware to our sometimes blinded, dare I say, blinded law enforcement agency that will simply write it off and might make a report and then it disappears? And there needs to be some way of documenting those hate incidences in order to make an intervention to prevent the actual hate crime from even occurring. Is there any comments or any suggestions on that?
Well, I can make a couple suggestions. I mean, I think one suggestion is that if you are feeling that you're not getting, that these incidents are not being, you're not getting the reception, you're not feeling like you're being heard from the local law enforcement, you can reach out to the FBI, you can reach out to Jared and I. We have those connections with local law enforcement, and sometimes they just need to hear that, look, this is, you know, it might be like the you know, one of 100 complaints you received today, but this one we're really concerned about. Can you take another look? Can we, you know, put together a, you know, just look into it, that sort of thing. And, you know, the FBI is keeping statistics on these. So if you report them directly to that FBI tip line, there's going to be a record of it. That's not to say that, you know, it's going to be acted on, but again, you can reach out to our office, and if there's something that's happening that needs to be, that is certainly escalating or might escalate, we want to know, we want to help, and we can facilitate those connections. Yes, sir.
Maybe kind of following up that with all of the things that were on your initial video, I would say most of us probably feel that all of those could have been prevented, should have been prevented by someones that knew what was going on in that individual's behavior. So is there any thought of penalties for people within the family, within the, you know, the group, the hate group or whatever, that have some responsibility and can be prosecuted for that, along with the individual who very often is shot or killed in the episode, so that's over and done with. But here are all these other people that fostered or fermented that behavior.
Yeah, I think, I certainly think there are criminal offenses that could cover those types of behavior. I think one of the recent shootings, I can't remember which one it was, but it was a recent school shooting. The parents have been, I think, indicted for supplying the kid with a gun. So those are, I mean, that's kind of on the extreme. I think probably what you're talking about is
like failure to report is probably
your kid's in trouble, your kid's showing these disturbing things, and you haven't done anything about it. So I don't know if you wanted to add anything, Jared.
Yeah, there's really not anything, at least in the federal landscape, for that. Now, some states might have that, and I know you looked at some of that this time, but generally the failure to report, that's going to be difficult, and especially on the federal side, we're really not going to have anything in that regard in our toolkit.
But it does speak to the, to the responsibility of all of us to look, in our own communities, with our own families, if there's something problematic to, address it. But, you can only, do what you see and hear and live with and those sorts of things. So
Yeah, that's why this area is so important for, the community to be involved in, and so that they can at least report what they're seeing, even if that's not a crime. It could lead the FBI or the investigators into potentially preventing a crime.
any other questions? Okay. Turn it back over to Bill.
Thank you. We could spend all day on something like this, and maybe we will at some point in time. Just to follow up on a couple of comments, great questions. We have a lot of issues with juveniles and who are troubled, who are in difficult situations at home, who, for the most part, are falling under state jurisdiction. And so our office is working with state prosecutors, with school resource officers, with the juvenile court system on the state side when we've identified someone who we think is going to perhaps act out and do something like we talked about here today. So it's very challenging, and a lot of times those juveniles are in homes where we're not getting much help from the parents or from the guardians. And so then the state has to step in and try to do what it can do to provide resources to a child who's not getting the resources at home that he or she needs. And so that is a big challenge. And I recently met with and was briefed by the highest levels of the FBI, and the challenge with juveniles potentially being engaged in these types of things is tremendous. And it's something we haven't fully gotten our arms around yet, but we're working on it. In a couple of months, on November the 15th, at the Independent Bible Church in Martinsburg, the FBI will be hosting the West Virginia Faith-Based Security Summit. It is for active shooter preparedness in houses of worship. Wish we didn't have to have such things, but there are going to be a series of those across the state. And the one for the Eastern Panhandle will be on November the 15th from 6 to 9 p.m. The FBI will be pushing out more information about it. It's open to anyone, regardless of what church you might go to or whether you go to a church at all. It's open to the public, and the idea is to help prepare for such situations that we just saw about. We saw from what happened in Milwaukee in 2012. So keep that in mind. Put that on your calendar. I'd just like to thank you all for attending, all of those who attended in person and online. We're going to continue to engage with the public on these types of issues. We've got the presentations in Morgantown and Wheeling coming up. If you or your group has a specific request for a topic to be covered for your organization, whatever it may be, let us know. You might want something just on fair housing. You might just want something on hate crimes. Let us know. We can come in and do those one-off presentations. Not a problem at all. We've got the talent in the office to do those kinds of things. Just call us at the U.S. Attorney's Office at 234-0100, and somebody will be able to meet your need. I'm sure of that. So thank you very much, and enjoy the rest of your Monday.